Good morning, everyone. The meeting will be starting shortly at 9:30. Could I ask that people make sure they've got the name and where they're from in their title, please? I noticed there's a couple from the council and Mr. Dutton. If you could change your name, if you go over to if you click on participants, it will come up on the right hand side. And you'll see your name, and if you just go to your name, there's three dots and it says rename. So if you just put like Peter Dutton Gladman, please, just then it makes it easier for everybody to be able to see who you are. Thank you.
Okay, fine, noted. Thank you.
Good morning. I've just admitted someone with the title of N361508. Can you identify yourself, please?
Yeah, it's Andrew Lysons, Planning Manager from United Utilities.
Right. Could you rename yourself so people are aware as to who you are? If you, do you know how to do that?
Apologies, I don't, I'm afraid, no.
Right, no problem. If you go to the bottom of your screen, you'll see participants. If you click on that, it will pull up a list at the side, right-hand side.
Yeah.
Yeah. If you just hover over your name or your thing, and there's 3 dots, and it'll say rename.
There we go.
Right. So, but if you could put where you're from, so your name and where you're from. So it says United Utilities. If you could just put that on, please. Then everybody knows, especially with it being live streamed, people will know who you are and where you're from. That's brilliant. Thanks a lot. Thank you. The meeting will be starting in a couple of minutes. So do people want to be putting their cameras on, please, so we can get everything lined up? I think we're still waiting for the council and probably having a separate meeting. I think, or have I got? Oh, we're there. Yeah, regarding the council, Mr. Brophy and Miss Neville, would you just add the LCC bit, please, so people are aware as to where you're from? Brilliant, thank you. Brilliant. The inspector will be joining the meeting shortly.
Good morning. Can everyone hear me? Thank you. The time is 9:30 and the hearing session is now open. It forms part of the examination of the Climate Emergency Review of the Lancaster District Strategic Policies and Land Allocations Development Plan Document and the Development Management Development Plan Document. My name's Ms. Joanna Gilbert and I'm the Inspector appointed by the Secretary of State to conduct this examination and to report to the Council in due course. The hearing today will be a structured discussion which I shall lead based on the agenda that's been previously distributed. And the purpose is to enable people in the virtual hearing to put forward their points of view and to help me to get the information I need. Before we start discussion, I'd just like to go through some formalities. First of all, can I ask Mr. Brophy from Lancaster City Council to introduce the council's team, please?
Yes, good morning, Ms. Gilbert. Thank you. I'm Maurice Brophy. I'm the Service Manager for Planning and Housing Strategy at Lancaster City Council. And with me this morning are, first of all, Diane Neville, who's a Principal Planning Officer in the Planning Policy team. Fiona Clark, who is a Planning Officer. Claire Powell, who is a GIS Officer. Susanna Dart is our Climate Policy Officer. And we have Paul Tucker, KC from King's Chambers, providing legal representation this morning. And sorry, I beg your pardon. And we also have United Utilities, Andrew Leesons.
Thank you very much. Good morning, all of you. And just in terms of other participants, if I can just ask you to introduce yourself briefly in turn. So for Lancaster University, please.
Good morning, Miss Helen Clarkson from CBRE on behalf of Lancaster University.
Thank you very much. And for Story Homes, please.
Good morning, I'm Matthew Dover from Bank 119 Stantec for Story Homes.
Thank you, Mr. Dover. Good morning. And for the Home Builders Federation, please.
Good morning, ma'am. Mark Berrant from the Home Builders Federation.
Good morning, Mr. Berrant. And for Derwent Development Management Limited.
Good morning, ma'am. It's Mark Hailwood from ATP, as you say, acting for Derwent Group.
Good morning, Mr. Hailwood. Thank you. And for Taylor Wimpey UK Limited, please.
Good morning, ma'am. Paul Nellis from Astir Planning on behalf of Taylor Wimpey.
Okay, thank you very much, Mr. Nellis. Good morning. And I believe we may also be expecting somebody representing Wayne Homes.
Good morning, ma'am. Stephen Harris from Memory Planning, representing Wayne Homes.
Thank you. Good morning, Mr. Harris. And also somebody representing Gladman.
Good morning, ma'am. Peter Dutton from Gladman Developments.
Good morning, Mr. Dutton. Thank you. And let me just double check. Is there anybody that I've missed who hasn't already been introduced either by the council or by themselves? I think that's it. So if I've missed anybody, I do apologise. They could put their hands up.
I do have a colleague, ma'am. It's my colleague John Burkhead, who's a strategy demand manager at United Utilities.
Thank you very much. Good morning, Mr. Leeson. Okay, right. So you will all have met or spoken to the programme officer, Carol Crook. She's responsible for organising the hearing sessions and for the publication of documentation, and she's your first point of contact if any assistance is required in terms of the examination. In terms of housekeeping this morning, if you can please make sure all mobile phones are turned off or switched to silent. You'll be aware that the hearings are being recorded and live streaming is also taking place. In terms of breaks, I have timetabled regular breaks between the hearings, and I've timetabled for matter 3 to take place over sessions 1 and 2 today. So it's my intention to take a break around 11 o'clock if we're not finished. And if anybody does need a break in advance of that, please do make me aware. Just in terms of yesterday's hearings, which some of you will have been present at, because a number of officers of the council were in the same room yesterday, there was a little bit of a delay with microphones becoming operational. So today, if any of the council officers are in the same room, can I just ask them to pause very slightly before they start talking, because I was missing the very beginning of sentences yesterday. I don't think I missed anything particularly important and got the gist of it, but just for everybody's benefit, it would be helpful if they could pause very slightly. In terms of documents, all references during the hearing to the plans will be to the single track changes versions of SD 01.1 and SD 02.1, which are available on the council's website. Prior to the submission of the plans to the Secretary of State for examination, Regulation 19 consultation took place, and I have all of those representations before me, and I will be taking them into account. I've previously identified matters, issues and related questions, and they're available on the Council's website. And an agenda for each day of hearings has been based on those matters, issues and questions, and that is also available on the examination website. I hope you didn't encounter any problems in joining the hearing today. During the event, unless you're speaking, it's very helpful if you can keep your microphone muted. That avoids interruptions, and you can choose whether or not to turn your camera off. But I will invite people to speak at particular points. If you hear something that's been said which you wish to respond to, please do use the hands up function in Zoom to indicate to me that you wish to speak. Please don't speak unless invited to. And when you're asked to speak, please turn on audio and video. And if possible, please put your hand down after speaking as well. Otherwise, I'll come back to you. Just in terms of the chat function on Zoom, this should only be used if somebody is having a significant IT problem and they're having to leave the meeting and inform everybody of that. Given that there's, I think, something in the region of 18 participants today, I won't necessarily notice if one person disappears suddenly, but I would hope others, including Crooks, will be keeping an eye on that. If you can't connect to the event for some reason or lose connection, please first try to rejoin the event in the way that you joined earlier. And if you still can't connect, please contact the programme officer by email or by phone, and her details are on the council's website. Just before I move on, has anybody got any concerns about technology or general management of the event today? No? Okay, thank you. Just to provide an overview of the examination and my role, I'm tasked with considering the soundness of the plans in accordance with the criteria in the National Planning Policy Framework and whether they're legally compliant, and the hearings are intended to assist me in that regard. So in submitting the plans, the council considers that they are sound, and this is the starting point for the examination. If you're challenging the soundness of the plans, then please explain why and what changes would be necessary to make them sound. And I have read all the hearing statements that have been prepared, as well as the original representations. You don't need to repeat these, but if you do want to take me to a particular point, please do identify the document, the page number and the paragraph number if possible, so that I can go back to it in due course. And please be concise and specific. It's open to the council to propose further changes to the plans, and I did ask them yesterday if they could keep a record of any possible changes that arise during the hearings, with reference to a table of modifications. I also confirmed that we'll be having a mop-up session on Friday the 7th of October in the afternoon to go through matters arising from discussion over the week of sitting. This is a session which the council and I will participate in, but anybody may observe that. And any main modifications would of course be subject to future consultation. The examination remains open until my report is submitted to the council, and no further representations or evidence will be accepted after the hearing sessions are finished unless I specifically request otherwise. At the end of the hearing sessions, in the mop-up session, I hope to indicate the likely timescales of the next phases of the examination, with discussion with the council on that point. Before we move on to the agenda for today, does anybody have any questions at this stage about any procedural matters? No, thank you. Okay, so moving on to the first policy for discussion under Matter 3, Sustainable Design, Energy Efficiency and Renewable Energy. This is policy DM29, which is entitled Key Design Principles, and this is a policy within the Part 2 plan, as are all the others that we're discussing in Matter 3. So I asked a number of questions of the council in my matters issues and questions, and in terms of policy DM29, I'd just like to ask the council first of all whether they consider that policy DM29 is positively prepared, justified, effective and consistent with national policy. And Mr. Brophy, if I could ask you to introduce any of your team who are going to deal with that.
Yes, that question is going to be answered by Fiona Clark, Planning Policy Officer.
Thank you.
Good morning. Yes, the council do consider it to be positively prepared, justified and effective. The majority of the policy already forms an adopted policy which has been found sound at a previous examination. We have added some points to better reflect the climate emergency and the methods that the plan can utilise to improve that development, reduces the carbon output of development, provides better resilience and mitigation for new development. It is in accordance with Chapter 12 of the NPPF. it is just the additional points are justified in terms of picking up solar gain, sustainable design, enhancing the use of sustainable transport measures, and green and blue infrastructure. It sets out some additional principles that are then carried through into the more detailed policies, particularly in DM30, A, B and C of the plan, and the renewable energy policies. I think the remainder of our answer is really covered within the hearing statements already. There is one aspect that has been brought up by the developers in terms of the use of solar gain within development, and that is in bullet point 2 of the policy. We have included in there maximise solar gain, but that does need a slight amendment to ensure that we're relating to maximising solar gain within winter periods rather than the summer periods. And we suggest that maximise is amended to optimise, and there's a clarification within the supporting text to relate to the difference between winter and summer solar gain.
So just to clarify, so you'd have, so maximise at criterion 2 would be replaced with, so ensure opportunities are taken to optimise solar gain.
That's right. That would ensure that during the summer months, solar gain is minimised, yet it is maximised within the winter months to reduce the need for heating and energy.
And then in the supporting text, there would be clarification of that. And
yes.
Where would that be?
That would be within paragraph 8. With it, sorry, paragraph 30 under DM30A, because there's reference there to solar gain. So there's a link between the two policies there.
Just bear with me a moment and I'll go there. Okay, thank you for clarifying that, Ms. Clark. Any views on that from the other participants? No? Okay, thank you. So if, Ms. Clark, you could provide modifications to that effect, and that go in the list of modifications and actions that the council needs to do.
We will do.
Thank you. Okay, so just moving on to a point in DM29 that I asked about in my matters, issues and questions. So you've talked about criterion 2 in terms of solar gain and so on. In terms of criterion 7, which is another of the new criteria to be introduced to policy DM29. This reads, meet the requirements of policy DM30C, sustainable design and construction, ensuring development contributes to both mitigating and adapting to climate change and is resilient to the ongoing and predicted impacts of climate change. So with that one, is it clear at criterion 7 which policy should be referred to? Is it purely DM30C, or is it a wider range of policies than that?
It would be a wider range of policies, including all the DM30. So the new DM30 A, B and C, all of which deal with sustainable design and construction.
And the council does consider it necessary to cross-reference to all of them?
In this case, yes, because they are all connected. There needs to be that reference to ensure that there are the links between the three, and once an applicant reads through the key design principles, they are directed to the more detailed policies at 30A, B and C.
Okay. Do any of the other participants want to come in on that point? Mr. Dorber.
Thank you, ma'am. If I could just go back to criterion 2, sorry, I misunderstood your question. I thought you were asking if we had any comments on the council's amended change, proposed change outlined there by Ms. Clark. We've got a further point on limb 2. Okay. At the moment, we consider we welcome the change from maximise to optimise. We have no issue with that. It seems to make sense. At the moment, the wording that ensure opportunities are taken, it seems to insinuate that these have to be taken when there are other considerations in terms of sustainable design that have to be weighed up as well. So we would say that actually, as worded, it would seem that the solar gain requirement would seem to trump other considerations such as optimizing density, for example, in that particular element's role in ensuring sustainable design. So we would wish to see a further amendment on top of what Ms. Clark suggested, just at the beginning of limb 2, to just say where appropriate. So there's that added flexibility so we can weigh up further sustainable design considerations as well. Thank you.
Thank you, Mr. Dauber. Can I take the council's view on what they've just heard from Mr. Dauber?
We consider that unnecessary. The phrasing of the policy is to ensure opportunities are taken, and that would be balanced against all policies and aspects of development in accordance with section 38(6) of the Planning and Compulsory Purchase Act. The plan needs to be read as a whole. This is just looking for the opportunities that are available to enhance solar gain for energy generation. The policy also talks about the use of site layout, orientation and design for energy efficiency and energy generation. It wouldn't be seen or used in isolation. It's just a key aspect when you're looking at everything else.
Thank you. Okay, I'll go back to Mr. Dauber first of all, and then go to Mr. Behrend.
Thank you, ma'am. Just in terms of Ms. Clark's point on there's already a reference to seeking to ensure a layout that ensures maximum energy efficiency. That could potentially be taken to cover solar gain as well in a more clean way rather than explicitly mention it. I take a point that the plan has to be read as a whole, but then under limb, I think it's 7, they're making specific references to other policies within the plan. So if we were taking the policy, if we're taking the plan as a whole, we wouldn't necessarily need to do that either. So it's just a consistency point, I guess. Nothing Ms. Clark has said there is sort of made us change our position, really. It's one for you to weigh up, I guess. Thank you.
Thank you, Mr. Dauber. Mr. Behrend.
Thank you, ma'am. Very, very similar, and agree with the points that Mr. Dauber has just made and made previously. I think in terms of what the policy should do, it should be looking to balance that and place the context within which this policy needs to be addressed, which is the efficient use of land, which is a requirement of the NPPF. So I think it is important that that context is set out. And similarly, if the context in terms of the policies that follow directly from these policies in terms of DM30, then it should really reflect the position that's set out, I think, early in the local plan itself in terms of the efficient and effective use of land, in terms of maximising that. So it really needs to be set within that context. And I think it is possible to read it outside of that context. And I think it's important in terms of clarity to the decision maker as to how it goes forward. So I think if there is going to be that level of cross-referencing and the council considers that necessary, then actually I think it is important to ensure that the context within which this policy is read is in terms of the efficient and effective use of land. Thank you, Mark.
Thank you. I saw quite a number of hands go up before and after Mr. Tucker's. Before I go to Mr. Tucker, it might just be worth checking. Got Mr. Aylward Were you wanting to comment on the same point?
Thank you, Ma'am. Yes, I broadly concur with Mr. Dorber and Mr. Berent. I don't see why it's necessary to cross-refer to policy DM30C in Lim 7, policy DM29. I think it could quite straightforwardly start at the word ensuring. Doesn't need that cross-reference there. The aspiration is the same, and it's also because we actually have quite a few issues around the technical requirements of DM30C anyway. But I think for our purposes there, we think the cross-reference is not required. Otherwise, you'd have cross-references to all the plans in every policy, which would goes against the generally agreed approach. So I just don't see why that cross-reference is needed in that instance. Thank you, Mum.
Thank you, Mr. Elwood. Okay, Mr. Tucker.
Thank you, Madam. Not entirely sure why the colour of my hand raised is slightly different, which is a bit bizarre, but never mind. Two points, and I think they're 2 points which are important to separate out. The first, responding to Mr. Dorber's notion that one should bring in the where appropriate phraseology or something like that into criterion 2. We talked about that yesterday in relation to different context. However, in criterion 2, you've got the initial words ensure opportunities are taken. So self-evidently that phraseology presupposes that there are opportunities to be taken, and therefore you don't need a phrase like where appropriate. So that's the first point. So as a matter of policy construction, you don't need that wording within criteria number 2. The second point is point raised by Mr. Berent and by Mr. Dorber relating to what I think arises from paragraph 125, paragraph C of MPPF, which is the injunction that authorities should refuse applications which fail to make efficient use of land, taking account the policies in the framework. I think the point that's being made is that imperative is missing from this policy, and that should be a general principle in its own right. So whilst I appreciate that it's made by Mr. Dorber and Mr. Berent in the context of these are all factors which should be taken subject to the efficient use of land, then I think it's a wider point that's actually being made as to whether or not a general key design principle should be whether one makes efficient use of land. Well, I'm not convinced that's a design principle, frankly, in relation to that. It's more of a policy principle as to how you approach land, albeit it has self-evidently design ramifications. But it's perhaps a point upon which we need to reflect as to whether or not there is a justification. And if it was justified, then one could either add a separate criteria or use it as part of the preamble, i.e. the council will expect development to make efficient use of land, subject to other principles, and then list the criterion. But we'll reflect upon that behind the scenes as to whether or not there is warrant to bring that within this particular policy. So there's nothing between the parties that's an important principle. It arises from paragraph 125C, but it's whether or not it firstly should appear in the policy, or whether in fact it's actually a different task that this policy is doing, and if it does, how it should appear. So again, Madam, I wonder if that's one you could perhaps leave with us to consider behind the scenes.
Okay, thank you, Mr. Tucker, for clarifying that. Any input from any of the other participants on those points that they've just heard from Mr. Tucker? No? Okay. So what I think I'll probably do is reflect on what I've heard in terms of where appropriate for criterion 2, and also on what I've heard in terms of criterion 7. And if the council could take away the thinking about 125C, and also perhaps discuss their thinking with those parties that are in the hearing today who've expressed an interest in that issue before they come back to me. I think that would be constructive. Thank you. Okay. So we've covered criterion 2 and criterion 7 so far. One very brief mention in criterion 1. I appreciate it isn't a part of the plan being amended, and it has previously been examined, but the council might want to do an additional modification on pallet, because that's the one that refers to your mouth, not materials. Okay, it's a regular problem. And then in terms of criterion 8, which deals with accessibility and highway safety, I will go into transport issues, and I'll come back to you in a moment, Mr. Aylward. I will go into transport issues later today, but I did just want to ask the question of whether criterion 8 was actually repeating criterion 9 and criterion 13, and whether the council wanted to consider the need for that additional criterion, bearing in mind what's already said in the plan. Might be something to think about for the transport session, because there's a number of instances of that kind of issue in the plan. So, Mr. Aylward, you had your hand up. Over to you.
Thank you, Mum. I may be jumping too far ahead. Sorry, I didn't know whether you were finishing on DM29. Just on clause 22, a similar point about cross-referencing to another policy, and also an emerging SPD as well that the council has consulted upon. Again, our view would be that there will be no need to cross-reference to those policies and document, or certainly not to the policy anyway. And obviously we've made separate points on DM62, as you'll be aware, but we think that the clause should stand in its own right without reference to the DM62.
So this is incorporate electric vehicle charging.
Correct, yeah. I'm assuming that, have you, sorry, Inspector, have you had sight of the draft SPD that was consulted upon recently?
No, I haven't.
Okay, all right. Because perhaps there's a question for Mr. Tucker to deal with, but obviously, the council has sought to provide some additional guidance to that emerging policy, and I'm not sure whether or not that's something that would want to be discussed as part of this examination.
Mr. Tucker?
Thank you.
I'm not sure why that would be the case. It may be an entirely legitimate point that Mr. Aylward is making, or not, but I'm not sure it's a matter upon which you can report in relation to soundness in terms of the SPD, and more importantly, how it has ramifications for your assessment of soundness of the rest of the plan. So I'm struggling to see how a draft document of that nature should be placed before you. I don't think the council will have any difficulties in placing it in the examination library if you want to see it, madam, but I'm still struggling to see how it would be relevant. In essence, that would follow on from the plan once the partial review's been adopted. But I'm again, it's either right or wrong in its own right, rather than a matter that concerns this examination. But not pushing back in terms of it going in the examination in the library if Mr. Aylward wanted to go there. But I'm not sure that you might want to see it. So I'll seek your guidance, madam.
Okay, perhaps it's something we can touch on this afternoon when we get to transport. But just in terms of the point that Mr. Aylward has raised in terms of, it's again the point of cross-referencing, which does occur a lot in the plan. It seems to be something that the council chooses to do here. And I appreciate that some of the cross-referencing is in policies which aren't being examined under the climate change review. In this instance, we've got cross-references to DM30B in criterion 21, and DM62 is amended. It's amended from policy DM31 to policy DM62 in criterion 22. So did you want to cover anything more, Mr. Tucker, or any of the council's team on the cross-referencing issue?
Yes, if I may. I think the reason for the cross-referencing arising from the partial review is because it is a partial review, and it's therefore drawing particular attention to policies which are additions or have changed. So I think there's a particular justification in this case as to why that's being done. In terms of the wider proposition about cross-referencing a plan, certainly I'm old school and you don't need to do it. But ultimately, the remainder of those references are there, and they've gone through that process of examination. But in terms of these changes, there is actually a justification for it, we think. But again, we'll see your guidance on that, madam, if you think that misguided, then so be it. But here, better that somebody looks at the plan and knows actually you do need to look at DM 30C if you're applying DM 29, because DM 30C is something new that you might not have seen 18 months or so ago.
Okay, thank you. Mr. Aylward, you'd taken your hand down? Thank you. Okay. So was there anything else in detail about any of the content of policy DM 39? I do have a further question about the supporting text, but just before we move on, does anybody want to raise anything else in particular about DM 29? Okay, I'm not seeing any hands go up. So I just wanted to cover point 9.5, which I did raise a question about in terms of this covers garden space, and the previous text, which in the adopted plan refers to the following levels of provision will be encouraged, and the council has chosen to amend that to expected within the climate emergency review, and then has made some additional bullet point changes to add composting infrastructure, edible plants and trees, and ensuring that private gardens are free from flood risk and well drained. So just in terms of increasing the requirement, really moving from encouraging to expecting something to occur, has the council carried out any assessment on gardens in new developments and assessing whether gardens in new developments are generally meeting those requirements, or whether there is a particular gap or issue that's present in Lancaster? If the council would like to respond to that.
I can't say we've actually researched the amount of garden space that is coming forward on applications, but certainly in terms of the applications that we have seen recently, the garden spaces are being achieved on the majority of the new greenfield sites. There are some cases, of course, where that would be reduced or flexible depending on the size of the site circumstances. For example, there's one site at the moment that has got a very constrained width, and to make it viable for the affordable housing that's proposed on there, the garden spaces are reduced, and the way that they're provided on the site are changed. So in the majority of cases, which is the consideration for the plan itself, those levels are being achieved.
Thank you, Ms. Clark. Mr. Berendt.
Thank you, Mark. I think the concern we have is this shift from encourage to expect, which is an expectation is very different to something that's being encouraged across an area. An encourage would suggest you can take elements from those bullet points and apply them, and it's a far more flexible approach. Expectation, especially expectation, even though it is set outside a policy, is a very different wording. And what I can't see is the justification for the change to expectation. And also it means that where has it been viability tested? And in terms of viability testing, each of those elements under that paragraph 9.5, it's not just the new elements, because there is now an expectation from the council that it is just a confusing position that the council have created here. And I would suggest that the expectation should be moved back to in terms of encouraged, and that would be a far more appropriate wording within the supporting text to this policy. So I think it's just that nature of that change, really, from an encourage to an expectation, especially outside of policy, Mel.
Thank you, Mr. Berendt. Okay, Mr. Tucker and then Ms. Clark.
Yes, madam. Dry legal point from me, and then obviously Ms. Clark will respond in substance. It's important to remember, notwithstanding Mr. Berendt's concern, that paragraph 9.5 isn't policy. It can't be policy. There's very clear case law, and that's called Cherkley Valley and the Secretary of State, that says you can't have policy within the explanatory text of a plan. That's to help you understand how to apply the policy itself. In this instance, for example, criterion 15, and that's the the policy application. So all that the authority is doing by changing from encourage to expect is ramping up what it is that they're looking for when somebody's bringing forward an application that should be judged against policy. And it's essentially to achieve the objectives which underpin the policy as to how you would achieve that. So dry legal point, notwithstanding the change in language can't introduce a policy test, whether it be a higher or more rigid policy text. That's only in the policy itself. Ms. Clark, I don't know if you had anything to add.
Mrs. Tucker's just dealt with what I was about to say.
Okay, thank you. Anything further on that point before we move on? No? Okay. Thank you. So just wanted to move on now to policy DM30A. And policy DM30A is the first of a group of 3 policies which replace policy DM30 sustainable design and go into a greater level of detail than that previous policy. So policy DM30A deals with both residential and non-residential development and sets out a stepped approach in particular for new residential development for carbon reduction. And first of all, can I just ask the council on policy DM30A whether the council's approach is justified, effective and consistent with national policy, please?
Yeah, Ms. Clark will address this one again.
Thank you.
Yes, we do consider the policy to be justified and in compliance with the NPPF and PPGs and various other acts that relate to addressing climate change within planning policy. I think we have covered this in some detail in our hearing statements, and unless there's anything specific you would like us to raise or address now, it's probably best that we leave it at what you've been able to read.
Thank you. So just in terms of where we are in terms of acts and written ministerial statements, is the council's view that it can actually it is in a position where it can go beyond building regulations?
Yes, it is.
Mr. Berendt?
Oh, I was already unmuted. Sorry, I was unmuting and muting myself frequently there. I think the
occupational hazard.
Yeah, there's a couple of points to really make with regard to the council's position on this. I think the first one is regard to including the regulation with regard to 31% improvement. Obviously, this is addressed already through building regulations that came into force this year. So that is a repetition of the current position with regard to building regulations. And as such, it's not required to be included in the policy. Recognise that the policy may have been prior to this, but the case now is that it's there and shouldn't be repeated. I think with regard to the following stages in terms of the 75% uplift in 2025 and going beyond that, again, obviously the council are looking at the future home standard and which the government are proposing to introduce from that point. First of all, we don't know whether that is going to be the case and whether the 75% improvement is going to be brought forward, whether it will be higher, whether it will be low, we don't know. So that's the level of uncertainty as to what the expectation is from government. And in terms of what the council statement that Ms. Clark referred to is around the lack of acknowledgement within that of the written ministerial statement and planning practice guidance, which reinforces that, which says that council shouldn't go beyond the 20% improvement set out in the very old now Code for Sustainable Homes, level 4, But it is reiterating that point that was made in the written ministerial statement of 2015 and is still referred to in PPG, and that hasn't been amended. And I think it's important to recognise that, as the council again notes, Section 5 of the Planning Energy Act says that any should be in line with national policy on that. So that is the guidance that has been provided, and the policy indeed in terms of written ministerial statement as to the degree to which councils can go beyond within local policies, and accept that allows the local plan to go beyond that. But that now has the government haven't changed that, and they've moved beyond in terms of building regulations, and that is the approach that's being taken by government with regard to improvements in energy efficiency. It is through the building regulations, and not now through planning policy. There was an element, but that has now been taken forward. So I think those are the elements that's missing really from the council's statements, is that reference to that essentially the limit in terms of what planning policy can do, which has then now allowed the government to shift into a more regulatory framework through the building regulations and energy efficiency. Thank you, Mark.
Thank you, Mr. Barrett. Mr. Dorber.
Thank you, ma'am. Mr. Barrett's covered quite a few points that I was going to talk about in terms of the percentages that the council are hoping to achieve. And so it's just a couple of further issues building on that. The first one is in terms of the viability assessment. I know we're going to talk about viability on Friday, so I'll keep it brief on that one.
Please.
Yeah, so the use of the fabric first approach has been referenced within the viability assessment, but the detailed representations prepared by Cushman and Wakefield in the Regulation 19 consultation shows that the detail proposed isn't sufficient, and therefore there isn't appropriate evidence to justify the use of fabric first, as opposed to using the building regs that, as Mr. Barron has already covered, are the national standard. The second point, it's just down to the implementation of this requirement, really. So as I understand it, it'll be using DM30A is requiring the fabric first approach to be used in terms of design. You could therefore get a planning consent on a full planning application by following this approach, doing things properly. But when it comes to building control, presumably they would be using the building regs in order to assess what can actually be developed. So it seems that there could be almost a dual consenting regime in place, where if there is a difference between the fabric first approach and what's outlined in building regs, which one would take precedent? If it was the national standard in building regs, then it sort of undermines the point of taking a different approach if bits of it are going to be taken out when it gets to the building control stage. So it was more of a general question. I'd just be interested to hear what if the council has considered that, and if not, we would suggest that a move to just using building regulations as a national standard would seem a prudent approach, considering that they're reaching the same standards in terms of carbon reduction anyway. Thank you.
Okay, so thank you, Mr. Dorber. So there's a few points there for the council to respond to. First of all, in terms of Mr. Barrett's points about the written ministerial statement of 2015 and the planning practice guidance and the interrelationship with various acts, and the change that's occurred through building regs more recently in terms of building regs 2021. And then there's also the implementation of the fabric first approach. If we park the viability of the fabric first approach for Friday, but in terms of the implementation of the fabric first approach and how that would work with building regs. So there's a few points there for the council to come back on. Just before the council does come back, Mr. Elwood's hand went up in the meantime. Mr. Elwood, is it another point on on a similar theme?
It is. So our clients' interests are to do with non-residential development. And in that instance there, the policy is referring to the use of BREEAM standards as the council's preferred metric. In the same manner, we think it's more appropriate to use the building regs metric, because that's the government's preferred approach. So we're not necessarily convinced that the use of BREEAM is the best way forward. And then even if the inspector decided that the BREEAM metric was to be an appropriate positive approach towards achieving the council's climate emergency aims, we still think that the way this is worded is negatively worded. We rather than saying that BREEAM will be required, maybe a better way to deal with it is proposals that can achieve strong BREEAM credentials should be given positive weight. I think it's just a different spin on the policy. We think that the preferred approach should be building regs, and if a developer can demonstrate other positive credentials, that should be viewed positively rather than being sort of deemed negatively in the alternate. I just think it's the wrong way around, really.
Thank you, Mr. Elwood. Okay, so a few points there, Mr. Tucker. Sorry, I can't hear you, Mr. Tucker, you're on mute.
And it was a really good point I was making as well.
Sure
in terms of the substantive justification for the policy, I'm going to leave that to colleagues who are in a different part of Lancashire to me. Can I just deal with two preliminary points, if I may, and I may need to come back afterwards. The two preliminary points are the proposition that there is a problem because of the overlap between the building reg system and the planning system, and that can you do something which is different in the planning system to the building reg system. And then the proposition, and that's Mr. Dorber's proposition, and then Mr. Barrett's proposition about you can't do it anyway because of the approach in terms of national policy. So the more straightforward one to answer is Mr. Dorber's. Is there an inconsistency between what might happen in terms of the consenting regulation under the planning permission and then the consenting regulation under building regs? They're doing two different jobs, and there is no difficulty at all in relation to there being a more stringent requirement at the planning stage compared to the building regs stage. So, for example, it may be that for building regs that there may be a particular requirement for internal layout of accommodation for the elderly, but a scheme may be consented under the planning sphere because it's intended to provide much higher spec in terms of internal layouts and corridors and whatever, and that's part of the justification as to why consent is granted, because the particular need for that higher spec type development. So the fact that planning consent requires something which goes beyond building regs of itself as a matter of law doesn't matter. They're two different regulating consents dealing with two different things. One's the in principle decision as to whether this is the right place for this development to go and this form of development to come forward, that's planning. The other of which is how it comes forward. So no difficulty in that regard. The more involved question is Mr. Barrett's question is, can you do it anyway? Well, there's a couple of points to make, which are grandmothers and egg sucking points, if you'll forgive me. And it's to distinguish between matters of policy, matters of guidance, and matters of law. Firstly, as a matter of law, the test of soundness is an open textured test, which has to have regard to national policy, but fundamentally it's an overall judgment that you, madam, have to form in relation to the plan as a whole. I know that planners love to say that this policy is sound and that's sound and this is sound, but it's actually an overall test. That's the Barrett case, which came out very shortly after the 2012 MPPF came out. So it's an overall judgment you have to form. Second point is guidance, i.e. that which is within the PPG, and I'm thinking particularly the 2015 guidance within the climate change chapter that Mr. Barrett refers to, which does indeed make the reference that Mr. Barrett refers to, now 7 years old. The courts have been very clear in relation to the status of PPG. It is not national policy. It's guidance, it's authoritative guidance from government, but it's not policy. So when you are judging subparagraph D of paragraph 35 of MPPF, consistency with MPPG is not the test for judging whether one is consistent with national policy. Guidance doesn't count in that regard. And that's the solo case. Mrs. Justice Lever made that very clear in that context. So the issue is, what is it that's said to be that we are inconsistent with? In terms of ministerial statements, statements from the minister which lie outside of MPPF can be considered to be statements of national policy. So I'm not going to take the point that a ministerial statement isn't national policy. There have from time to time been authoritative statements of policy issued through ministerial statements. So, however, the question is whether or not a statement which makes reference to now outdated standards 7 years ago, way before half of the councils in the country issued climate change emergency declarations, way before some of the factors that we've drawn attention to within our evidence, represents an up-to-date statement of national policy. Now, it's right to say that it's still there. It's not being withdrawn. It's not being withdrawn by the government. It's not being backed away from. But nonetheless, when you are judging consistency with national policy, you, madam, as part of your overall judgment, are entitled to form a view as to whether that policy is or isn't up to date in exactly the same way as you would in relation to a local plan policy. So we take the view that there are other factors which justifies deviation from that 2015 ministerial statement. Oh, how the world was different in 2015, though we didn't know it. But one of the ways in which the world was different was at that stage, the urgency of the climate change emergency, certainly so far as my clients are concerned in this local plan, was not quite as apparent as it self-evidently is today. So there are reasons why we are seeking to go beyond that statement of national policy. And fundamentally, going back to my first point, which is that the test of soundness is a matter of law, even if you, madam, considered that there was an inconsistency with that aspect of national policy, we say that there are good reasons why nonetheless this plan should be found sound, namely the factors that we've pointed to and all the substantive points that my colleagues will no doubt deal with in due course. So it's wrong to say as a matter of law that there's a difficulty because of inconsistency between what's controlled under building regs and planning. And it's wrong as a matter of law to say that you can't do it in relation to going beyond building regs. What you have to do, however, in forming your judgments to whether the plan is sound on this basis, is form a view about what weight you give to statements of national policy from 7 years ago, and having regard to all of the other factors that we've drawn attention to in our evidence, whether or not we are overall consistent with national policy and whether there's a good reason to go beyond it. And that's, madam, as the courts would say, a quintessential planning judgment. And that really lies at the heart of what my clients are trying to do in relation to this case. I don't know whether colleagues sitting in the glories of the room in Morecambe have anything to add to that.
Can't see any hands up from them, but I'll.
We've nothing to add on that point.
Okay, thank you, Ms. Clark. Okay, so just in terms of hand up order in response to that, I think it was Mr. Aylward first of all.
Yeah, thank you, ma'am. Just a very brief response to Mr. Tucker there. I don't disagree with much of what he said there, to be clear, but there was a point he made quite strongly about taking the overall balance and the overall kind of direction of policy from the plan. That being the case, we do think that it would be, going back to our point about the application about non-residential development, that whatever if there is an aspiration to achieve a BREEAM standard, for example, it should be given positive weight where proposals seek to do that, rather than be worded restrictively, because then you can sort of, you can then look into see how that particular proposal can be viewed more widely. We just don't see how it's beneficial to be worded restrictively. You'll be aware, ma'am, that we've also made other points elsewhere about the relative viability of these types of development, and I won't go into those now. But of course, if more onerous obligations are imposed and worded restrictively, that isn't going to assist deliverability. Thank you, Mum.
Thank you. And then I think it was Mr. Dorber and then Mr. Barrett.
Thank you, Ma'am. I appreciate Mr. Tucker's clarification in terms of the relationship between the planning standards seeking higher specification and building regulations, presumably the inference being seeking lower. I think our point was mainly to do with the aims of both are the same in terms of it being a 31% reduction. So it's not necessarily that the planning standards would be higher and therefore would automatically be okay in terms of a lower building regulation standard. It's the fact that they could potentially be seeking to do two different things. For example, you could have a lower standard in terms of, I don't know, insulation with fabric first, but you have a higher standard in terms of, I don't know, glazing or orientation or whatever, and you reach the overall reduction of 31%. So it's just in the case that if there was a specific conflict between two constituent elements of the fabric first requirement as opposed to building regulations, that's where we could perceive an issue. It's not that we're necessarily against fabric first where it goes higher if there's a viability justification for that. It's the fact that they're both in effect seeking to do the same thing in terms of overall carbon reduction. That was where our confusion came in. Thank you.
Thank you, Mr. Dorber. And then we've got Mr. Barrett.
Thank you, Mark. Just it's coming back really in terms of the PPG and recognise what Mr. Tucker has said with regard to written ministerial statements and PPGs. And it is important to recognise that the PPG and the reference to written ministerial statement was amended in 2019. So whilst the written ministerial statement was from 2015 and the PPG was first drafted in 2015, the amendment, and it has been amended in 2019. So the government have revisited and looked at that particular paragraph and continued to make reference to the written ministerial statement in 2015. So to suggest that it's 7 years out of date, I think is slightly disingenuous in terms of the where the government's position is. It is they have looked at it and they have chosen to continue with that from that point of 3 years ago. So I think that is an important element to consider within your considerations and with your consideration of soundness. And then it is coming back to the fact that the legislation in terms of the 2008 Act did say it has to be in line with what with national policy. So then that refers back to the written ministerial statement, and which is continued to be referred to in 2019 by the government in terms of PPG. So that reference is still there. Thank you, Mark.
Thank you. And Mr. Nellist.
Thank you, Ma'am. I just wanted to sort of add at this point, I'm conscious of not repeating myself throughout the sort of course of today and tomorrow, because a lot of the points we've made in our matters paper come back to the viability points, which I'm sort of picked up that we probably get into in earnest on Friday at the viability session. On this policy in particular, it was just to say that our sort of main concern with the transition arrangements is probably the practicality of it and whether or not that's been properly viability tested, and therefore whether it will actually be effective or whether it will threaten delivery. So I guess mainly just to signpost that, yeah, that this is one of those policies, as was the previous one, policy 29, that I think we'll come back to on Friday in terms of your specific questions at matter 8.
Thank you, Mr. Nellist. Okay, so there's a fair few points there for the council in terms of the positive versus negative wording of DM30A in terms of employment or non-residential development, the potential for specific conflict between elements of the building regs and the policy situation, There's Mr. Barrett's point regarding the PPG-WMS situation, and then the transitional arrangements. So, Mr. Tucker, I don't know whether you're going to perhaps deal with one of those points and hand over to Ms. Clark, but over to you.
Yeah, well, can I start? Just to deal with Mr. Dorber, I think Mr. Dorber is looking for comfort of the fact that something which complies with policy, in the sense of it, you've got to comply with it to get your consent, should also then be taken as a benefit in the overall planning balance. Well, he can have reassurance, because that's planning orthodoxy. For example, the Secretary of State has given substantial weight in multiple call-in inquiries to the provision of policy compliant affordable housing, notwithstanding that all it does is comply with policy. There are a number of other references that we could throw, but merely complying with policy doesn't preclude something which is beneficial being given positive weight in the overall planning balance. That's the first thing. Second thing, Mr. Barrett's right, there was a revision in 2019, but the foundations of the written ministerial statement was 2015, for all the reasons that we've talked about before. And that's part and parcel of the weight you should give to that, madam, as to whether there's a justification now in 2022 to move beyond it. And that's a planning judgment. And it's important to note that the test as a matter of law, section 20, subsection 5B of the 2004 Act, requires a judgment of soundness. That's it. You've got to have regard to national policy. You don't have to slavishly follow national policy, and there may be justification in particular instances to go beyond national policy, or indeed to deviate from national policy. But our point is a simple one, which is it's a matter of planning judgment in all the circumstances of this particular case. This is an authority, if I may say so, which is not just engaging in student politics of declaring a climate change emergency, but actually is trying to do something about it in terms of pushing its climate change agenda through how development comes forward in this area. Yes, it may be going beyond what is specifically required by national policy, but that doesn't mean it's not lawful, nor does it mean it's not justified. And you've got the substantive points that we make in all our evidence. Those were the points I wanted to come back upon. I don't know, Ms. Clark or any of the rest of the team, whether there's other points they want to raise.
Ms. Clark?
Not in respect of that element.
And in respect of any of the elements that you've just heard from Mr. Elwood, Mr. Dorber, Mr. Behrend, or Mr. Nellist?
Sure. Well, if I deal with some of the broader aspects of the percentage reductions and how they relate to building regulations, and then I'll pass on to Ms. Dart, who will be able to go into some more of the detail. And then if we come back to the BREEAM after that. The policy was initially written prior to the building regulations without any certainty of them being introduced. The percentages were chosen, and the partly chosen against building regulations because that provided a very clear and recognised way of determining the reduction in carbon levels. The 31%, yes, it is broadly similar to the building regulations. The policy does, however, encourage the use of the energy hierarchy. So first and foremost, the fabric first approach, and then the use of other methodologies to reach that limit. It provides a transition and helps developers move towards changing the build fabric to meet the 75% and the specific fabric first approach required in 2025. Now that 75% reduction is expected through a fabric first approach, which has a whole host of other reasons behind it and improvements, which Ms. Dart will explain more. It isn't simply a rehash of the building regulations. And the other point to make with that is there's no certainty at the moment that those building regulations will be introduced or at what level they will be introduced. So if I hand over to Ms. Dart, she'll be able to explain a little bit more of the detail around that.
Thank you very much. So just to address a couple different things, the while our percentages remain that of the adopted building regs Part L and the proposed future home standard, there's a very different way to look at carbon. You can either look at carbon as a matter of offsetting carbon, such as through the energy use in the building, then offset it by, for example, solar panels, or you can look at carbon through reductions first, so reducing the amount of energy that's used first before offsetting takes place. If you take that second approach where you reduce the amount of energy that's used first in order to reach your carbon reductions, that comes with a whole host of co-benefits. And one of the primary things that we're looking at as part of this climate emergency local plan review is how do we reach those carbon emission reductions while also maximizing co-benefits. This we kind of picked up yesterday when we talked about health and well-being. So when we reduce overall energy use in a building through a fabric first approach and through the energy hierarchy, before we need to deliver energy to heat that building, that provides co-benefits such as reducing overall energy use, which reduces bills. In fact, some fabric first homes can reduce their bills by more than 80%. You can see reduce the lifetime emissions for carbon lifetime emissions. You improve the health and well-being of the occupants. This is also included for indoor air quality and for warmth in winter, and improved insulation also makes the home cooler in summer. And it allows for true net zero later, because you can actually, because you've reduced the amount of energy so far using a single phase energy system or solar delivery, you can actually meet the requirements of the building's energy use and completely offset building energy use. And this is outlined in the we've outlined that in our evidence-based document P 20.2 technical appendices 1. There is also the concern that the taking a fabric first approach, or the approach that's suggested by the council in DM30A, will have difficulties meeting building regulations. The fabric first approach that we've modeled the policy after is the passive house approach, as well as following guidance from key bodies such as REBA and LEDI. Across England, there are many different passive house developments, including in this district and including one that is currently under construction right now. This covers all different types and tenures of different fabric first homes, as well as both residential and commercial development. So there will be no issue in meeting both fabric first as well as building regs.
Thank you. Anything from any of the participants on what they just heard from the council? Okay, so just in terms going back to the beginning of the steps in policy DM30A, in the box, you've got on adoption of this local plan a minimum 31% reduction in carbon emissions against Part L of the Building Regulations 2013. So as you say, it was, I think it was Ms. Clark initially said it was initially written prior to building regs being amended in 2021, and we've got 2021 with it coming into force June 2022, and then transitional arrangements in place to June 2023. So there is the possibility that if this plan were to be found sound, the plans would be found sound, they would be adopted before that 2023 transitional arrangements date has been reached, given it could be, for example, say February 2023 for adoption of the plans. What I'm wondering is, if you were trying to use this policy as a developer, and you've got the three-stepped approach on residential of the 31%, then 75%, then the net zero, would it be confusing and unnecessary to have that first step in place, given the change that's occurred in building regulations? Now, I recognise what you've said in terms, I think, start in terms of the way that requirement is reached could be different in terms of fabric first, but does it actually cause unnecessary confusion? Is it reasonable to have that first step in anymore, given where we are now?
Yes, we believe it is reasonable, partly because of the section below the box that looks for the use of the energy hierarchy for the reduction, but also in terms of the transition. This policy will only apply to planning permissions granted after its adoption. And if we're looking at, say, February next year, it's likely that new developments would then not actually be commenced until possibly 6 months after that, where the building regulations would be in place anyway. So the transition is probably going to be very, very similar. It just highlights that need at this early stage in conjunction with the building regulations, and it also keeps in that that encouragement of the energy hierarchy use.
So what if, for example, the policy was modified to refer to the new building regulations, but also make reference to the importance of using the energy hierarchy?
So I am not quite sure how that would work.
Well, neither am I, if I'm honest, in terms of, well, I'm not quite sure how it would work for a developer coming, you know, you'll be working with developers who are dealing with development across the whole country, and they'll be becoming used to dealing with the transitional arrangements and the incoming 2021 building regulations on their developments. And then they come to Lancaster and they've got to deal with something slightly different. So how is it clear to them what they're expected to do versus what they're expected to do elsewhere?
The clarity is there in the section below the box that talks about the encouragement of the fabric first approach. If you were minded to do so, the first point, I suppose it could be amended so that that first point and that first point only relates to development commenced with a similar date as the building regulations. The clarity needed is because of the energy hierarchy. There is additional information in the forthcoming SPD, the guidance, which will continue with after adoption or once we've got your report and we know what changes are necessary. We'll continue with the SPD to provide developers with additional guidance how to achieve each of these carbon reduction levels.
Thank you. Mr. Tucker.
Yes, madam, just thinking exactly the same way of approaching this as Ms. Clark. Your point, as I understand it, is there's an added layer of complexity between somebody that gets a consent in February 2023, but before the end of the transition period, and have then speedily got on with things. What on earth are they to do in terms of the policy? And it's all quite complicated. I think Ms. Clark's point is, well, one could change from it being adoption of the plan to a date which is consistent with the coming into force, the end of the transition period. That may be the neatest way of dealing with it, and then that makes it clearer. But perhaps that's a point we can again take back and think about, because you're only then not biting upon the very speedy developer that's getting on with it, having got a consent in February of 2023 and is looking to secure their consent much more quickly. So I think, given we're dealing with that smaller element, it's probably something that can be avoided by just altering the date slightly.
Mm-hmm. Mm-hmm. And it would all depend on how long it took the council to deal with conditions, etc.
Exactly.
Yeah. Okay, Mr. Elwood.
Just a point of interest and pedantry, really. The last point within the box about basically the how the requirements will be triggered. Again, I find that slightly odd, because in my experience, you would apply for a building control process post consent, for a number of dwellings together. It's inevitable there's going to be an example where different houses in the same development are going to kind of fall either side of those thresholds there. I would have thought that the relevant approach would be to tie these standards, whatever they are, to the date of consent, rather than to some future date of commencement of a construction, because, as we all know, times to discharge conditions can vary. So I find it odd that last clause is there. I would imagine that's going to be extraordinarily difficult to police down the line, particularly for developments of a larger scale. It's just inevitable that they're going to run across these sort of arbitrary time thresholds. Thank you.
Thank you. Does the council want to respond on that?
The concern with having it tagged to a single planning permission is the length of time that it may take for some of those planning permissions to be developed. Say, for instance, the scheme of 500 houses, which typically in this district seems to be developed at about 25 a year. You've got a scheme meeting the lower carbon reduction requirements for 10, 15, 20 years into the future. The building regulations does deal with this to some extent, as in the changes, because it talks about the commencements of each house. Anyway, it's not like the old way of dealing with it, where a notice was put in for a whole site even before a planning permission, and the building regulations was pegged to the time that was submitted. The commencement dates and the transition period in the new building regulations are changed to commencement of each house, and that's why we're also taking that stance within this policy. So it is similar in terms of the building regulations. It also ensures that, say, a planning permission was granted next summer, those dwellings are not meeting the 31% reduction only in 10, 15 years time on a very large development.
So Mr. Elwood and then Mr. Behrend.
Thank you, that's helpful. So just thinking as a planning consultant dealing with trying to assist developers, would that therefore mean that in practice that you'd award a consent on date X, and then there would need to be some kind of mechanisms to police, wouldn't there, so when these buildings were delivered in time? So is that essentially sort of a planning condition route? If it's being managed through planning as well as building regs, is that how you do it? I'm not sure otherwise how this would be policed.
Thank you, Mr. Elwood. Mr. Behrend, and then I'll go back to the council.
Thank you. I think it's really drawing on a point that you raised earlier in terms of it's the added complexity to the system in terms of trying to achieve the same outcomes, in that you're twin tracking something through planning policy and then through building regulations, and how that then apply. It seems to be placing becoming overly complex, in not only for the developer but also for the council in terms of monitoring, managing and delivering this expectation that actually is already set out in building regulations, and moving forward through a regulatory framework. And then I understand in terms of fabric first, and the council may want to encourage that, but in terms of the policy, it just adds to that complexity that will slow development down in terms of coming forward. It puts additional conditions, all those elements that really become unnecessary because of the changes and the stepped approach to building regulations that the government are taking, and sort of seeking to move it away from this the complexity in the planning system, which are already overly complex, and put it in a regulatory framework. So I'd suggest, Ma'am, that it's just not needed, or if it is needed, it just makes reference to the building regulations, and then within supporting text says encouraging fabric first approach within development. But I find it an overly complex approach to a problem that's already being addressed through building regulations. Thank you, Mel.
Thank you. Anything from the council on that?
I think as Mick Starr explained, there is a difference between the fabric first approach particularly and the building regulations. Whilst they are achieving the same carbon reduction requirements, there's a whole host of other benefits with the fabric first. So there is a distinct difference there in between the building regulations and the planning policy itself. We don't believe that this would add complexity. It works very well with the form and the transition within the building regulations. With a planning application, one of the aspects within these policies is the production of a energy statement and a sustainable design statement. Now, you would expect those to set out how this will be dealt with as part of the application, and then it would be simply a matter of a condition saying that development commenced of a certain date would need to meet the 31% reduction, and then after January 2025 it would meet the 2025 reduction. There'd be no more necessary checks and balances with it or conditions or within that. We would expect the developer to carry out some monitoring, but again, that's within the building regulations, and we may deal with that through another question in further down the line, which Ms. Stark can provide some more detail of the interaction with the monitoring there.
Perhaps she could cover that now.
So I think this is just picking up a difference with SAP 10 as part of the building regulations that came in force this year, and that the building regulations requires that you both calculate the carbon emissions of the dwelling at the design phase, and then there has to be photographed evidenced throughout the build process to minimize the performance gap before you have the final SAP assessment done. So that just highlights that the building regulations already has that monitoring in place, and the council wouldn't be requiring anything different than what the building regulations is already asking. I think another important thing to do is that if anybody decided to go down another accredited path, such as Passive House, those different optional building standards have their own accreditation system, and again, they have their own requirements. But so we wouldn't be asking for anything beyond what the building regs or those optional building standards would be requiring anyway.
Thank you, Mr. Elwood. Is that a legacy hand, or have you heard something you'd like to speak about?
No, it's a new hand, but I'll just raise a point. Okay. I wanted to raise a point about sustainable design statements, but perhaps that's to come later.
Yeah, certainly. I do have a question about sustainable design statements and energy statements. Just looking at where we are time-wise, we've got 5 minutes before the end of session 1. Just wanted to ask, in terms of the specific timings that are proposed by the council. So we've got the 1st of January 2025 for 75% and the 1st of January 2028. So could they just take me through why those dates have been chosen, what the rationale is, and what that links up with?
The first two elements are in line with building regulations, so it provides some consistency and an ease of reference for developers there. The third is ensuring that the net zero is in line with both the council's climate emergency for net zero for 2030, so that development coming forward would then be net zero. It also helps achieve the government's longer term net zero ambitions at ensuring that new development does not continue to add to those carbon emissions long term.
So this is working on the basis that in 2028 you would be giving planning permission for something. It may then take some time to deliver, and that by 2030, which is the council's stated date for trying to achieve zero carbon, things would be starting to hit that. So you're trying to front load it a little.
We are, yes. And also development the way that the policies worded, development commenced its development commenced in 2028, so that there is a little bit of leeway in there. And we're just taking, our aim is to have regulated energy emissions to be carbon zero. That's where the council are aiming to get at as soon as possible to meet their own climate change objectives plus those of the government. The work that we've had done talks about the time that's needed to adapt to provide that, so we've left that transition within that area.
And as far as 2025 is concerned, you mentioned building regulations there. I take it you're referring to the government's stated intentions.
Yeah, the future homes, that's where they were aiming to be. Sorry, I interrupted. That's where they were aiming to be for 2025. We don't know if that's going to come forward, but we have the ambition and the certainty that we do need to achieve that. So that's why we've used the same date.
Okay, thank you. Right, I do have more questions to ask on policy DM30A and on various elements relating to that. So perhaps we can come back to that after the break and in session 2, and then we'll go on to cover DM30B, DM30C and DM53. So very sorry to Lancaster University, who've been sitting there very quietly for some time, but we will get to DM53 in the end. Okay, so the time is now 10:58 and the hearing is adjourned until 11:30. Thank you very much, everybody, for their contributions. See you all in half an hour.
Good morning. The inspector will be joining the meeting shortly. Could I ask that you turn your cameras on, please, in readiness? All right, thank you. Right, has everyone got the cameras on, please? Thank you. All right, the inspector will be joining the meeting shortly.
Hello, good morning. The hearing into matter 3 is resumed. I'll just start the session with an apology. It's come to light during the break that the parish council have decided to cut the grass outside my house. So if you do hear any interruption and need me to repeat a question, please do ask. They'll be coming and going. I can hear them in the background now, but hopefully you can't. Thank you. So just going back to policy DM30A, and I do have some further questions to ask in respect of DM30A, which will probably be best framed in the viability session on Friday. But is there anything else that any participants wanted to raise about the policy itself before I move on to asking some questions about the supporting text? Mr. Dorber.
Thank you, ma'am. It's just in relation to the requirement of a sustainable design statement. So at the moment, as you'll be aware, there's a national requirement for a design and access statement on all major development proposals. There's also a local requirement within the council's validation checklist, which I believe was last updated in 2020, for an energy statement. It seems from reading the policy that the major difference between the sustainable design statement and a design and access statement is the need for the latter to include, the former, sorry, to include an energy statement. Given that that's required anyway, I'm not sure why there's a specific need to request that in or demand that within the policy. It would seem that a simple amendment to the validation checklist to ensure that the energy statements that are already required reference things like how proposals respond to the energy hierarchy, and design and access statements should be covering issues concerned with sustainable design anyway. So I'm not sure we see the need for this reference within the policy. Thank you.
Thank you. Mr. Elwood, was it a similar point?
Thank you, ma'am. To some degree, so for us, kind of we see the same point about there being an adopted standard for energy statements, but also through reading the policy, it does appear to us that the aspiration is predominantly about securing more energy and carbon efficient construction. And obviously we're conscious of the fact that there are, and then it also refers later to, because we're interested in employment development, this being applied to major development. But we're also conscious that with other applications that we do for developers, that there are major applications such as Section 73 applications to vary hours controls, for example, or change of use that may not require any physical works at all. So we would suggest that if this is to be required for the reasons the council kind of promote, it should be in relation to developments that will involve significant construction activity. It doesn't really, in our view, have any merit if you're simply, for example, changing the opening hours of a supermarket. You know, that doesn't involve construction activity, but it would still be a major.
Thank you, Mr. Elwood. So Mr. Dorber's point on the sustainable design statement and the energy statement and the design and access statement actually picks up on some of the questions I was going to ask. So if the council could respond on that, that would be helpful. And then also respond on Mr. Elwood's points in terms of how the policy would be applied, what kinds of applications it would actually be applied to.
In terms of the requirements, having those details within the policy, set them out very clearly, and it also supports the validation checklist. One of the aspects behind a validation checklist is ensuring that the requirements are in accordance with policy, so that there are clear links there. We don't believe that this provides a dual requirement. The sustainable design statement can be written in conjunction with a design and access statement. It's just a case of picking out sections that are very important for sustainable design. So you can include your sustainable design statement within your design and access statement, or you cross-reference and work the two together. The energy statement will need to incorporate very specific elements that deal with the energy hierarchy and the carbon reduction requirements. Yes, it is in the validation checklist at the moment. We will be going through the validation checklist and reviewing that again on adoption of the plan to ensure that it encompasses all the elements that are necessary to address the changes in not only the climate emergency review, but also the last review that hasn't necessarily all been picked up within the validation checklist. In terms of the major development, the concern with changing the requirement for the statements to major construction is the definition of what major construction would be. Also, there may be a change of use from a building that has no heating within it at the moment to a residential development where there would be a considerable amount of carbon output through the heating required and the other elements of energy within it. So there's a necessity for an energy statement to cover a wider variety than just new build development.
And if it were the case that very little was changing apart from the actual use, so you've referred to a change of use which would obviously require quite a lot of physical change to the fabric of a building if it was changed to residential from, say, a warehouse use or something like that. But in instances where actually there's very little physical change, what would happen then?
Well, at the moment, has been picked up. It is very broad in terms of the provisions. One of the modifications we could look at is rather than changing it to a major construction as such, we'll be looking at the energy status of a building. This is defined within the building regulations, and we could do something similar within the policy.
So what would that look like?
Could I pass over to Ms. Dart on that,
sure.
please?
Yep. So we could, if you, as the building regulations put out set out, you could have, for example, an amendment to this, which requires it instead of major construction activity, as has just been suggested, but rather in the change of the energy status of the building. So that would be where, for example, one part of the building was not heated, but then is renovated to be heated, or you have a commercial building where the energy use was very low, but then the energy use becomes very high as part of that change of use. Or you could, we would also suggest then also having an amendment in there where a change of use results in a dwelling being added to that building. Does that clarify that enough?
Thank you for clarifying that. Mr. Elwood, did you want to respond on that, or is that a legacy hand?
No, I did want to respond, really.
Okay.
we don't really make any points about changes from commercial to residential. I think that makes sense. But in other instances, there will clearly be examples where a fairly generic commercial building could move from B8 to B2 with no changes to the building at all. If there was any aspiration from a tenant to change the insulation or what have you of that building, that will be through building regs, that will be dealt with through that manner. That's not, I don't think that's even development really. Although I'm sure Mr. Tucker will confirm either way, like if I'm wrong there. But then also moving on, similarly, I raised the point before about Section 73s. There will be numerous examples of major developments that, for whatever reason, have to go through a process to change an operative condition that would have no effect on the physical form of the building. And I think the key thing here is to realise that the point made before, which is that this policy will inevitably align with the local validation checklist, as will be amended later on. And applications will go into the council, to the validation team, and either at that point or prior to, applicants will be obliged to provide a sustainable design statement for that type of development I've referred to simply say there's no change. It seems to be completely without value. I think a very simple clarification could be provided here to just eradicate that unnecessary step. And of course, through the validation process, the case officer might determine actually that they take the view that it is a significant construction activity and that document is required. But I think it's at the moment, it just brings in an unnecessary step for lots of developments, and obviously the next step I would raise is then just an impediment on deliverability. It just seems unnecessary, really, and quite an easy fix. Thank you.
Thank you. Mr. Dorber.
Thank you, ma'am. It's picking up on Mr. Elwood's point, really, in terms of the value of this requirement. Ms. Clark set out, I think, quite clearly that this wouldn't necessarily be a dual requirement because the sustainable energy statement will be covering quite a few of the things that will be covered in the DAS anyway, and it's in a sense taking it just slightly further. I suppose it's reiterating our point from earlier. Wouldn't it make just more sense to do this within the DAS and the energy statement that are required anyway, and amend the validation checklist as has been referred to, if required, to refer back to the policy and the requirements of the policy in terms of the energy hierarchy, etc. It just seems that making reference to this within the policy, there's no clarity that it can be accommodated within the design and access statement. In fact, the fact that it says the design statement shall include an energy statement, it makes it sound like a standalone document, which, because if you would have a sustainable design statement accommodated within a design access statement, which in itself includes another statement, it's getting quite confusing. It makes sense to just have the two that are already required for clarity. Thank you.
Thank you. Mr. Barrett.
Just to agree with the points just made by Mr. Daub with regard to the energy statements, it's a point we also raise in our statements and representations. But there's also, I don't know whether you want to consider this yet, Ma'am, is with regard to the new paragraph 22 and energy statements and the contents within that, and whether that's something you were going to address now or later.
I'm fine with you addressing that now.
I think it's really just regard to the, I think it's a point we raise with regards to the last point in that, in terms of the energy statement and the requirement in terms of whole life cycle carbon assessments and embodied carbon. I think this is a relative, quite an onerous requirement within an energy statement to request that of major developments going forward. I think there's a lot in terms of the extraction, processing, manufacturing, transport. So there's a lot that's in there that is difficult to assess in terms of moving forward, in terms of what is required and what is required of the policy in terms of energy efficiency of those buildings, rather than actually looking at the whole life cycle of all the materials used within the construction of those homes or buildings. I think to ask that is going beyond, and it's not clear what the council would use that information for with regard to it, whether it's how that would form part of the decision making within this, or whether it's just a request for that information, but with no actual reason for requesting it. So I think there's not really a need for that last element within the energy statement, and it's a concern that we have, Mel. Thank you.
Thank you. Mr. Nellist. Sorry, I think you're on mute, Mr. Nellist.
Sorry, ma'am. I was going to raise this point earlier, but it was sort of 2 minutes to 11. So I thought I'd hold off and see how this session started. It's just a point that sort of links a few things that have been discussed by those parties together. And it sort of, talking about the energy statement and the wording on that has drawn my attention back to it. It relates mainly really to the blue box, again, the transition arrangements. And I think someone raised the final sentence there about whether the requirements would apply at the date of permission or the date of commencement. And I think you raised the point yourself about whether this was, you know, how clear what was required of developers were in terms of, I think we talked about planning permissions that may be granted sort of, I don't know, say for argument's sake, this time next year, but would the delivery would span a number of years and go beyond the sort of second and third bullets in those transition arrangements. And I'm just a bit unclear, and I don't know if the council can clarify, because I didn't necessarily get this from the answer earlier, but it is, if we were a developer submitting a plan application, sort of say for argument's sake this time next year, but it was a development that would clearly be delivered over say 10 years or so, that would go beyond the final bullet, which I think is the one that we've got most issue with. I think Mr. Dorber referred earlier to Cushman and Wakefield's regulation 19 representations on the net zero point. I'm not sure how in an energy statement a developer would demonstrate that final bullet could be achieved at some point in the future. I think how this would be sort of monitored and controlled by condition was mentioned, but I'm just still a bit unclear as to how a developer would demonstrate that, I don't know, 7 or 8 years from permission, that the dwellings further down the line would meet that third bullet, when, again, I appreciate this is a point for Friday, but the Taylor Wimpey and a lot of other members of the consortium got serious concerns about whether that net zero point has been viability tested. I don't know if the council could just sort of re-explain how plan applications will be determined and that requirement to demonstrate that they meet that final point. I'm just a bit unclear still.
Okay, thank you, Mr. Nellist. So we've got a few points there to pick up on from the council. Ms. Clark or Ms. Dart?
In terms of the energy statement and the sustainability statement and the design and access statement and the connections, we're happy to look at modifications to ensure that there's no duplication and they all do work together. So we can come up with some alternative wording for you there if you wish. Now for the last point in paragraph 22 and the energy statement, I think Ms. Dart will be able to explain a little bit more about what's expected there and why it's required.
Thank you.
So we are looking at the whole life cycle carbon assessment, because if you're looking at the lifetime carbon, the country is committed to being net zero by 2050. And if we're looking at the whole life cycle of carbon, DM30A in terms of net zero is only applying to to regulated energy use, or that energy use which is covered by Part L of the building regulations. That represents roughly 25% of a building's carbon output, with about 50% of a building's carbon being associated with embodied carbon. Currently, the regulatory landscape in the UK does not support setting specific targets for embodied carbon. However, it does support, through BSEN 15978, a assessment of the whole life carbon of a building. Development proposals do have quite a lot of influence over the different whole life carbon assessment modules, having to do with the building materials that are used, and even the building materials, how they can be recycled later, as well as the whole life operational carbon. The council is not prescriptive in the approach that applicants take in assessing the embodied carbon of their proposal. And in the Sustainable Design, Energy Efficiency, and Renewable Energy Generation Supplementary Planning document, which has been subject to pre-regulation 12 consultation, there's a section within there which outlines different ways which that can be assessed. However, it's completely up to the applicant how they would like to do that. And it just provides applicants a way to demonstrate that they have considered the embodied carbon, which is about 50% of the carbon of their building, as part of their development proposal.
And in terms of Mr. Nellis' point, in terms of a developer submitting a planning application which gets approved in September 2023, but he's looking at knocking out homes across a 10-year period, potentially, how would they ensure in their energy statement that they would actually achieve those steps? Because they would obviously be affected by the 2025 and the 2028 points.
So if you are meeting the 75% reduction in carbon through the Fabric First approach, as proposed and set out in policy DM30A, that provides the opportunity for that building to have a very low regulated energy use profile that then requires very little added tech, such as solar panels, solar PV, or solar thermal, to bring that regulated energy use, to offset the regulated energy use of that building to net zero. And so the applicant would just have to demonstrate how they'd be able to do that as part of the design of their build at that 2028.
That does bring me to thinking about some viability points, but I will raise those on Friday. Okay. Mr. Aylward, you've got your hand up.
Yeah, thank you, ma'am. In some sense, this paragraph 22 just brings all these points to bear, really. It's obvious from reading this bulleted list, there's a whole host of quite detailed modelling work required for any sort of development, regardless of whether or not that development would actually have any construction activity involved, or would have any differential in terms of the way that the building is operated. And there appears to be nothing within this text, unless I've misread it, that gives the officers any discretion of whether and how to apply that. And it just strikes me that there should be that discretion, because there'll be a number of developments where this simply is just not relevant to the to the way the building would operate, and the way that that use would contribute or otherwise to the climate emergency agenda. We're not suggesting that the council is wrong in taking forward a policy approach to enhance the way development performs in that respect, but we think this is far too blunt a tool that doesn't really apply to many developments the council has to respond to. So I think we've made our points, but I think this, in many ways, this paragraph makes it even more abundantly clear how blunt and onerous this tool would be. Thank you.
Thank you. Does the council want to respond on that point at all?
Point in respect of paragraph 22 is it isn't policy. So there is the discretion there in terms of how each of these are met and what is included depending on the type of development. And as we mentioned, we are content with having a look at the wording of the policy and to look at how the three documents work together, and also with non-residential development referring to the change in the energy statement rather than every major development, so we can have a look at those modifications.
Okay, thank you, Ms Clark. So I would suggest that the council does look at those modifications. That would be helpful. In terms of my wider thinking on policy DM30A, I'm not going to jump to suggest any further modifications on that to the council at the moment. And that will probably be something, I'll talk to you about it again in the mop-up session on Friday, but it will probably be something that forms part of my post-hearings letter to the council, realistically. It's something I've got to think through quite a lot. Is there anything else on DM30A or the supporting text before we move on to DM30B? No? Okay, thank you. Right, so turning to DM30B, this deals with another aspect of the sustainable design and construction issue, which is water efficiency. So this is an entirely new policy, and I have asked a number of questions about that in my matters, issues and questions. So just as a first point, and I'm sure the council will bring United Utilities colleagues in if necessary, but is policy DM30B justified and consistent with national policy?
Yes, the introduction of the energy, the water efficiency requirement is consistent throughout the Acts, the MPPG and the MPPF. They all talk about increasing the resilience of properties to climate change and the efficiency of those buildings. We have put together evidence to support the introduction of the building regulations, water efficiency requirements. I know there have been mentioned that it is only relevant to water stressed areas, but we're quite clear that the guidance in the NPPF, whilst that is one aspect, it is not the sole aspect for the introduction of such a policy. The other point of note is that the introduction of the BREEAM element for non-residential property is already within an adopted policy. I think it's DM35 at present, so there's no change there. It's just moving it from an existing policy to put all the water efficiency and the efficiency measures in one place. Now, Andrew from United Utilities will be able to explain a little bit more about the justification and the evidence behind that.
If you'd like to do so, that would be great.
Thank you. I think, first of all, just to provide some context, the supply of water in the northwest is split into a number of resource zones. Lancaster falls within the strategic resource zone, is what we call it at United Utilities, and that serves around 7 million people. So the vast majority of the northwest, in effect, Manchester, Liverpool, and Lancashire, and indeed Cheshire. In that context, it is not simply a case of looking at the needs and demands of Lancaster. As was noted by Ms Clark, the PPG does refer to a range of pieces of evidence. The water stress documentation is not the only documentation that can be referred to. And it also references the importance of consultation with the Environment Agency. In terms of the sources of evidence that have been presented, these are quite well summarised in the Water Resources West statement on water efficient new homes. That does acknowledge that the North West is identified as having moderate water stress. It also refers to the national framework that was published in March 2020, i.e. the National Framework for Water Resources. And that notes that the Water Resources West region faces the second highest pressures on water resources in England, and that's largely due to population growth. Building upon that, the national framework does refer to a national ambition across the board, i.e. for average PCC per capita consumption for both new builds and existing properties to achieve 110 litres per person per day. And that is consistently referenced in the Water Resources West water efficiency evidence as well, that recommends the optional standard. There's also the North West Renovation Management Plan, which is cited in the PPG as a piece of evidence that can be referred to, and that requests the local plans deliver water efficiency measures via the optional standard. And it also identifies a high percentage of water bodies in the North West as not achieving good ecological status or potential, and that's with respect to the changes in flow and level, which are identified as a significant water management issue. And finally, there are levels of public concern that are referred to in the Water Resources West evidence, and that's backed up by customer surveys. And I think the final point is just to reference that the implementation of the approach and the optional standard for water efficiency is supported by the Environment Agency following consultation.
Thank you. Do any of the participants want to raise anything at this point about policy DM30B and whether it's justified and consistent with national policy? Mr. Berendt.
Thank you, Mark. In terms of the evidence, I think we were concerned that they didn't have put any further evidence forward other than that. And I think the council clearly have put some additional evidence forward, and I think that's for you to consider, Mark. I think our key concern really is with regard to the policy itself and to the with regard to the final element, which said which in terms of design of new development should maximise inclusion of water efficiency and consumption measures. And I think this is potentially really going beyond what is required. I think there is a requirement. I think to meet that and to make those improvements through the optional technical standards. But I think in terms of requiring them to maximise, I think goes beyond what is there. I think there are elements in terms of, obviously there's the different elements of viability that will take beyond, if you're going beyond what the optional technical standards that needs to be taken into account, which will need to be evidenced by the council, but also with regard to the wording. And I think it's that recurring to almost requiring to maximise rather than sort of looking to the potential to maximise delivery and that element. So it's the wording around that rather than to maximise. There are elements that they might want to consider, but it actually shouldn't be a requirement to consider because that is actually set out within the optional standard. So I think it's that balance between the two, Mark.
Thank you, Mr. Barrett. Anybody else? No. Would the council like to respond to Mr. Barrett's point?
In terms of its phrasing, it's just looking to ensure that developments do consider expanding and looking at the range of water consumption and measures that they can include. It doesn't necessarily mean to say that they have to go beyond the optional standards. It's just a case of looking at all those other options. I'm not sure if Mr. Lessons would like to add anything further on that.
I don't think there's anything for us to add, no.
Thank you. Okay. I'll let Mr. Barrett come back first and then Mr. Aylward.
I think if it is just to consider, then I think that should be reflected in the wording. I think it would be my point. I think if it is just an element to consider these options rather than should maximise, then I think it should be consider these options within development rather than that very far harsher wording that's currently in the policy at the moment.
Thank you, Mr. Barrett. Mr. Elwood.
Yeah, thank you, Ma'am. So a couple of points I've kind of rehearsed previously, really. One is his reference to this being required for major non-residential developments. You've made, I've made points before about types of major development that may or may not involve works that would relate to water efficiency, for example. So I think the same kind of points are raised there. I'm hoping you'll kind of consider those in due course as to how that should be applied. I think it would be the same would follow here. And the second part, I think, again, is that BREEAM is a metric that can be used. There are other metrics that can be used, including building regulation. So it's not necessarily clear to us why BREEAM standards should be adopted in preference to. And our other point was about viability considerations, which obviously we'll deal with on Friday.
Okay, thank you.
Thank you.
Mr. Tucker.
Just a simple point, really responding to Mr. Barrett's, and one always recognises a good point when one sees one. The use of the future imperative should is plainly intended to be forthright, and maximising is plainly intending to do what it says on the tin. I think Mr. Barrett's point is that there is some sense in using language which allows some degree of flexibility in the light of what Ms. Clark has indicated. I do wonder, and this is thinking out loud and one that we'll perhaps take away as a team, whether optimise may be a better word, given that it's an MPPF friendly word, as it were, rather than maximise if the future imperative is being used. So just the thought as to whether or not this is really a matter of slightly different language, which might meet the HBF's concern in that regard, but more importantly, maintain the intention that sits behind the policy. But we'll take that away as a team, if we may.
Thank you, Mr. Tucker. That seems sensible from my perspective. I don't know whether Mr. Barrett wants to come back on that at all. He's just muted himself instead of unmuting. I think.
Seems like a very sensible way forward. I must remember that and not speak out if I forget to unmute myself. Thank you, Rob.
Okay, thank you. Fine. So if the council can take away considering a modification on optimise rather than maximise, just on that point in terms of what is said there about inclusion of various measures. So there's some difference in terms of I think it was DM30. So there's reference in other areas of the plan. Oh, yes, it is. It's at DM30C, 0.5, talks about green/blue roofs and/or walls. And then in DM30B, there's only talk about green roofs. So I just wondered whether the council was content that having something along the lines of measures such as could therefore include things like green and blue, or whether it felt it necessary to be consistent with DM30C in that way.
I think the consistency would be the best way forward. So if we could change DM30B to reflect DM30C.
Okay, yeah, I understand that there has been a move more towards blue roofs of late. My 6-year-old green roof is now very, very old and tired in comparison to the latest technology, I'm sure. Okay, just in terms of Mr. Aylward's point on major non-residential schemes, did you want to deal with that at all, Ms. Clark?
And if you have a look at DM35, the existing DM35
okay.
plan.
And this is the crossed out text.
It is a crossed out text. So within the adopted policy, we already look for non-residential buildings, and that's of all scales to meet BREEAM excellent standard. We've recognised that there are issues, potentially some viability issues with the smaller developments, and there is scope with the larger developments, more scope with the larger developments to achieve this. So that's why we've simply reiterated that policy but changed its context slightly. I think the other thing to bear in mind is the BREEAM Water Excellent for non-residential buildings relates to the kitchen and sanitary ware within them. It doesn't relate to the processes.
Right. And how has the council been finding that element of DM35 to implement since it was adopted?
It's been looked at. It's been included as part of the energy statement, and I think we have conditioned it where necessary. I think actually there've been a limited number of applications where that would be applied.
And it's only been applied in the sense of kitchen and sanitary ware anyway.
BREEAM only does refer to those elements. It's not the processes.
Thank you. Mr. Elwood, you have your hand up.
Yes, thank you, ma'am. It's the last point. So just referring back to a conversation from earlier on about policy DM29, which cross-refers to DM30B. It's just there was a point that Mr. Tucker made that sort of I've been sort of thinking about since, which is a few things really. One is that I, perhaps similarly old school, don't think that policies need to be cross-referred to within the policy text. I also understand that that there are times as an applicant, it's helpful to know where the cross-referencing is useful. And finally, that information in the accompanying text isn't policy. Could the answer perhaps be to move the cross-referencing to the accompanying text and out of the policy, so that any reasonable reader would know by simply reading that collection of paragraphs that they need to look at the other policy, but it doesn't actually form part of the policy itself? That to me seems to be a reasonable solution that removes our concerns, but similarly assists a new developer coming in to know where else they need to look in the plan. Thank you, ma'am.
Council want to thank you, Mr. Elwood. Does the council want to respond on that? Mr. Tucker.
Oh.
Yeah, if I can start the ball rolling in relation to that. If we were dealing with the plan looking back to 2020, I would absolutely see the force in what Mr. Elwood says. I don't think that gets over our point, which is that we're dealing with a partial review, and the intention of the policies in the partial review, or the ones that are altered by the partial review, is specifically to flag up the newer policies. Now, within the text of the policy, that makes sense. If we want to relegate that to the reason justification, then there would be an issue in terms of consistency. So I'm slightly dubious about whether that gives rise to a lengthier exercise, which may be of lesser utility. It's maybe one that we'll reflect on behind the scenes, but at the moment, my reaction is certainly one of scepticism, whilst being sympathetic to Mr. Elwood's positive response in that regard.
Thank you. Okay, I've noted both your points. Just in terms of policy DM30B and the supporting text, just double check through any further questions. Just in terms of the documents that were referred to by United Utilities, can I just double check with the council whether all of those documents are actually included in the evidence library at the moment?
Sorry, Fiona. I was going to say that I've largely referred to the Water Resources West optional housing piece of evidence. I think the one that is potentially, I don't think you've got the national framework for water resources, and I don't think that I don't know if you have the North West River Basin Management Plan.
Thank you. Can I leave it with the council to double check the examination library against the documents that have been referred to by the council in their statement and by United Utilities in their supporting statement, and just confirm on Friday which documents could be added in? Is that workable, Ms. Clark?
Yes, we'll do that for you.
Okay, thank you very much. I'll just make a note of that. Okay, just checking through. Are there any other questions from any other points from participants on policy DM30B and its supporting text before we move on? No? Okay, so let's move on to DM30C. And that's the last of the three elements that replaces policy DM30, and this one deals specifically with materials waste and construction. And can I just ask the council first of all the question, is policy DM30C justified and consistent with national policy?
Yes, we do believe it is consistent. It looks at the use of various different elements of the construction to work towards a transition to the low carbon environment. The regulated energy use that's controlled by 30B relates to a small amount of carbon output for new buildings. The materials waste in the construction of them has a significant greater effect. So this policy is looking at how that can be reduced through the reuse of materials, how waste is dealt with on site, where possible using the renewables and such. Now Ms. Dark can explain a little bit more about the detail.
Thank you.
So this particular policy is, excuse me, I've got a bit of a cold, aimed at looking at the remaining holistic aspects of carbon and how it is carbon mitigation adaptation at a build site. It's particularly focused on major developments. It recognizes the embodied carbon of the building, which, as I mentioned previously, is about 50% today of the emissions of the building. And as we move towards more energy efficient buildings, that fraction is only going to increase. It also recognizes the national focus on how we should be using natural resources prudently, minimizing waste and pollution, and mitigating and adapting to climate change, and also recognizes that we need to have a long-term supply of construction materials, so they should be used prudently starting now. This not only impacts our long-term access to resources, but also can help to lower the embodied carbon of the building. And then we've also picked up again about the green and blue roofs, and having that included in the building because it does impact the energy efficiency of buildings, as well as providing, as I mentioned before, our focus on co-benefits, such as improving your water management and creating a space for biodiversity.
Thank you. And in terms of the third criterion,
yes,
so the full life cycle of the building, that
yes,
would be addressed via the energy statement that we've already discussed, presumably, in whatever endpoint it is, whether it's part of the design and access statement, part of the sustainability statement, or standalone. and that would then operate in the way that you've expressed in your forthcoming SPD, so that there will be different ways of explaining that. Is that?
Yes, the energy statement would provide, you'd lay out your data tables, and this policy would give you the chance to provide the narrative to that and provide the narrative to how that's been incorporated in the way that that's been considered.
Okay, thank you. And in terms of the modern methods of construction, so I think it might have been the Home Builders Federation that raised this point. I think they had a concern about whether modern methods of construction always sat comfortably with the council's other policies and the framework's other policies on design and housing mix. So how would that work?
So the key bodies across the UK recognize that modern methods of construction are one of the ways that we will be transitioning towards lower carbon buildings and the delivery of more energy efficient buildings. And projects are looking at different ways in which that can also contribute to different housing types and mixes. So I don't see that as being a conflict.
Okay, Ms. Clark?
And my colleague.
The key point with point 4 and the modern methods of construction is that that bullet point does start off with where possible. So that recognises that it would only be appropriate in some cases to use the modern methods of construction depending on the site circumstances.
Thank you. And Mr. Barrett.
Thank you, Al. Thought I'd respond to you raise our comments specifically. I think as we said in our statements, I think the use of where possible and considered are appropriate in these circumstances, because there are a variety of ways of delivering development, some of which will conflict with other elements of the plan in terms of mix and those elements. I think one of the key ones that isn't raised within this, and I recognise it is put elsewhere in the plan in terms of other policies, but in terms of raising the issue of viability with regard to these matters. In fact, actually across the piece in terms of 30A, B and C, obviously this viability is going to be discussed on Friday, but I think it is in terms of reference to viability and making sure that there is clear reference in terms of viability will be a consideration with regard to this in terms of the use of MMC, which can be might be cheaper going forward, but it could be more costly. So it's all those elements need to be factored into that viability consideration as what can be delivered and addressed through the sort of materials waste and construction element, as well as the other elements moving forward by the council. Thank you.
Thank you. I will be picking up on the point in terms of viability references throughout the plan on Friday. Mr. Aylward.
Yeah, thank you, Ma'am. Same point again, really. This policy is referring to sustainable design and construction. We think that the opening clause should refer to proposals for major development that involve significant construction, because obviously those that don't, the references to materials choices or life cycle analysis they wouldn't be applicable. I think particularly in this policy here, because the policy states it is focused upon construction, should ensure that those developments that don't involve that process shouldn't be obliged accordingly.
Thank you. Would the council like to respond on that point in terms of application and implementation of the policy?
We can have a look at the wording there. I think we'd be reluctant to include simply construction, because there will be schemes that involve demolition or internal alterations that need planning permission, but it is a phrasing that we're happy to have a look at and speak to you further if necessary.
I think if you could take that up with Mr. Elwood outside the hearings, that would be helpful, and feedback to me in due course, because obviously it's a point that Mr. Elwood has raised over a number of policies now, and it is helpful for all potential applicants to understand which policies are relevant to them. So if you can take that away and think about it, please. Okay, so Any further points? Mr. Dorber.
Thank you, Mo. It's just hopefully a relatively brief point on point 5 of the policy, the green and blue roofs or walls. So we've noted within, again, it's come back to viability, apologies. We've noted within the viability assessment, there's no reference to the green or blue roofs or walls. It seems like quite a significant oversight, but again, this will be covered within the matter. I think it's 8, is it? Day on Friday. And obviously our previous statement in terms of sustainable design statement still stand on this policy as well. Thank you.
Okay, thank you. So obviously the council will be aware in terms of Mr. Dorber's point about green and blue roofs, and that will be picked up on Friday. I know in this particular instance in point 5 it does refer to where appropriate, so that does give some flexibility. Okay, and we picked up the point yesterday in terms of monitoring about the references to policy DM30. I just wanted to confirm before we moved on that I did find some other references to policy DM30 across the plan because of the council's tendency to cross-reference. It's not just in monitoring, but it's also in, I think, tables of contents, and it's in policies SG7, SG9 and SG11. So it would be worth a double check of where the deleted policy appears. So if the council could do that, that would be great. Anything else on policy DM30C before we move on to policy DM53? No? Okay. So policy DM53 is in the chapter entitled Energy Generation, and it was an existing policy which is proposed for fairly significant amendment to include references to hydro energy generation, solar energy generation, and it also talks about energy storage, and there's a fair few changes relating to those changes in the policy in the supporting text. So I asked the question to the council in my matters, issues and questions, and I'll ask it again. Is policy DM53 justified, effective and consistent with national policy? And if the council could just respond to that, please.
Thank you. Yes. Yes, policy DM3 is considered to be justified, effective, and consistent with national policy. It's been laid out extensively within our hearing statement, but just to cover a few of the points is that it's clearly set out within the Planning Compulsory Purchase Act, as well as the MPPF, that local authorities should be supporting the renewable generation of renewable energy and supporting the transition to a low carbon future. Would you like me to expand on that anymore?
If you could expand on that, please, yes. Sorry to ask you to speak more.
No, it's fine. That's fine. I'm going to try not to cough. So this is also really critically important because not only for energy generation, but as we move towards a more modernized grid, we're going to need to have more renewable energy generation across the district in order to deliver the increased energy needs of a fully electric future, which is being seen as through our net zero future. The recently published British Energy Security Strategy, 10-point plan for green industrial revolution, and net zero strategy all recognize the critical and urgent need for the transition to low carbon energy generation, including renewable energy generation. Local authorities, as you know, are the ones that give planning permission for installations for both renewable energy generation and electricity storage. And both of those are critical for our transition to a net zero energy future. This is also really important in terms of meeting net zero, because we need to increase our local the approach to the 6 carbon budget analysis highlights that all of our buildings are going to need to be net zero by 2025, 2030, and we need to be able to deliver that renewable energy for them. And this policy simply sets out an expanded and more positive approach to renewable energy generation in the district. And again, really sets out clearly that the council is in support of these and sets out how we expect them to be delivered.
Thank you. Okay, so just first of all, turning to the issue of wind energy that's covered within the policy. So can I just clarify, in terms of areas that are suitable for wind energy, has there been a reduction in the areas suitable for wind energy in comparison to those previously identified in the adopted local plan? So there may be some confusion for me, but just if you could clarify that.
I will hand that to my colleague, Diane Neville.
Thank you.
Thank you. Yes, there hasn't been an intention to reduce the area. Certainly, the overall approach with this was that we were trying to make the wind energy opportunity areas a lot more visible and easier to see and identify than had been in the previous adopted local plan. However, having looked again at figure 13.1, having considered some of the matters that were raised in the hearing statements, we have realised that there has been a little bit of an error on our part in terms of how we've set out the wind opportunity areas in relation to our allocations that were approved through the last local plan examination. And if you were in agreement, our intention would be through a modification to remove the 350 metre buffer that we had put around the adopted allocations. So that does include, for instance, South Lancaster, North Lancaster, East Lancaster, all of the allocations that are in there, and then we would remove those because it's a fair point to say that at this point, even though they are allocated for some elements of residential development, the entire parcels of land on those allocations may not be residential development, and we don't know at this stage where that buffer would need to lie. So it would be our intention to remove that and to amend figure 13.1 and make that align with the policies map as well.
So 13.1, both images. So we've got one image of at the moment that's being deleted, and then a new image, 2 new images in the plan. We've got the wind energy constraints map and the opportunities. So would they both be amended?
Yes, that's correct.
As well, and just making sure that that corresponded with the policies map. So the policies map itself wouldn't change.
I might have to bring Claire Powell in on this one just to confirm whether the 350 metre buffer was put on the policies map, just for clarity, if that's okay.
If you could, please. Yes, thank you.
So with the 350 buffer, that was just put on the urban boundaries. It wasn't put on the original area of suitable for wind energy.
So what does that mean in practicality for the figures and for the policies map?
So it means for the new figure 13.1, so that 350 metre buffer would be removed.
Okay. And for the policies map, does that mean that there would be any change?
Could I just clarify, is that the adopted policies map, or is that?
As a result of the changes that are proposed as part of the submission of both plans, my understanding is that there are a number, not very many, but a number of changes proposed to the policies map, and they are relating to the green and blue infrastructure chains and corridors and wind energy. So it's really just clarifying that what we've got in figure 13.1 matches what we've got in the policies map, and then we have an additional issue of, do the insets match the policies map as a whole?
Yes, yes. Thank you. So it would be the changes just in the figure 13.1, and that will be reflected in all of the relevant maps. Yeah.
Okay, thank you. Any points from anybody regarding those changes in the buffers? Miss Clarkson.
Thank you, Ma'am. I think there's an element of confusion as to how this affects Lancaster University, because at present figure 13.1 is identifying the area to the east of the Belridge campus as being suitable for wind energy, but this is conflicting with the examination document P1.1.1, which is the revised policies map, where it's being shown as an area effectively unsuitable for wind energy. And I think, as you alluded to before, it's actually showing less of an area being suitable for wind energy than is in the current adopted policies map. It's effectively taken out a greater part of the university's estate as being suitable for wind energy. And that's where our concern and our objection to policy DM53 lies.
Would the council like to respond on Ms Clarkson's point, please?
I think we just need to check what that position is. As Mrs Neville said earlier, it's not been our intention through the revisions to the policies map to make reductions. There has been something which has occurred as we've given that consideration as to how it's presented on the policies map, but we are intending to revisit that and to ensure that we don't lead to a reduction in the area identified as suitable for wind energy.
Okay, perhaps as part of the process and prior to sharing those amendments with me, the council could engage with Lancaster University to ensure that they're au fait with what those changes would be. Okay, thank you very much. Just looking at my further questions. Anything further in terms of wind energy issues, Miss Clarkson?
Thank you, Ma'am. I think the main issue relates to the policies map. I think if I may suggest perhaps that the M6 motorway is added on to figure 13.1. I think that's where a lot of confusion comes from in interpreting that figure, because we've got major road infrastructure and rail infrastructure shown on the figure, but the motorway itself isn't shown. So I think it makes it a bit trickier for people to navigate that figure.
Okay, thank you. Can I get the council's view on the inclusion of the M6?
Yeah, we have no issue with that. It would definitely help. It's a major feature in the landscape.
Yeah, okay, thank you very much for confirming that. Okay. And I think I asked a question in DM53 about impact on nationally designated landscapes, and the council made reference to the possibility of bringing forward a modification to address that point. So I'd be grateful if the council could.
Yeah, that's our intention, Ma'am, to amend the policy to adding basically "and their settings" into that sentence, just for purposes of clarity. Okay, so if you could do a main mod on that, and that be included in the table of main modifications. Thank you. And so we've talked about the issues with figure 13.1 and the policies map and the insets, and
hopefully that can be sorted out relatively swiftly. Is there anything else on policy DM53 and 13.1 before we move on? Mr. Baird.
Thank you. It's just, I suppose, a quite small point in relation to the connection to thermal energy distribution, heating networks and cooling networks, and just whether that's sufficiently flexible, really, with regard to connection to existing networks, and whether actually there needs to be a wider consideration as to whether those existing networks are the most sustainable options moving forward. It may be the case that they're not, and actually connecting to the grid may be a more appropriate option. I think there's also concerns, I suppose, especially around consumers, in terms of the costs of communal heating networks, which can, well, we're seeing at the moment, be significantly higher. So it's whether there actually needs to be something around the cost of such elements to consumers, as well as obviously there's the overall viability of providing them, which is reflected in terms of feasibility of connecting to such networks. But it is an element of whether there needs to be flexibility in terms of what is the most appropriate form of connection, and whether it may not well be the communal network that's being provided at the moment within an area.
Okay, would the council like to respond on the heating networks issue, please?
Yes, please. Thank you. So just to be clear, there's three different issues here. There's one around the carbon intensity of the thermal energy provided. There's a question around the cost to the consumer, and then there's a question around feasibility. Is that correct?
Yeah, that's
Okay.
what it sounded like.
So I'll start with the carbon intensity. So there is definitely concern, particularly prior to the new SAP assessment, that you could be connecting to a thermal energy source, which is higher carbon intensity. However, with the new building regulations, Part L, this is covered in quite a lot of detail in Part L, Section 6. And as part of SAP 10, it's now recognized that connection to a CHP-driven high-temperature district heating or heat network will no longer be possible in many, many cases. So I think that takes care of that issue. And again, the council would expect that whatever heat source is used, that's the lowest carbon option that's available in line with the climate emergency declaration. In terms of cost to consumer, the government's direction of travel is to increase the amount of heat networks across the country. You're seeing this particularly with their consultation on heat network zoning, and as many of their different net zero documents lay out, thermal energy provision through heat networks is a key part of decarbonizing heat in the UK. The government sets out guidelines and recommendations that heat networks should demonstrate their compliance with appropriate technical standards, which is currently CIBSE's Heat Networks Code of Practice. The government recommends that. And the government also recognizes that heat networks are registered with the Heat Trust. The council and DM53 have clearly addressed that and taken government guidance and turned it into policy for local planning policy. And this will then provide that level of protection to consumers in terms of reliability of service and control of cost. And you can see that in bullet point 4 under thermal energy distribution, heating and cooling networks on page 145. In terms of feasibility of heat network delivery, the government's funding for heat networks is now focused on green heat, but the DM53 has also been clear under thermal energy distribution, heating and cooling networks, again on page 145, and it says where feasible, they should connect to existing networks or provide new purpose-built networks. So the feasibility has been addressed within the policy text already.
Thank you. Mr. Barrett, did you want to respond on that at all? No? Okay, thank you. Just from a purely practical perspective, if this policy were to remain in a very similar format to that which it's in at the moment, it has a number of criteria that are set out as Roman numerals at the beginning, and then later on, once we get to page 145, starting with solar energy generation, it then moves to bullet points. Now, having done many an appeal across the country with different planning policies, I can assure you, when you are in an appeal situation and you're trying to work out which bullet point it is you're talking about, it can be really quite time consuming and frustrating. So the council might want to consider applying numbers or letters so that it's actually quite clear at each point what the decision maker is referring to.
Absolutely.
Just to be helpful. But that's not a modification for me, but it's something the council might want to consider. Anything further on DM53? Start. You've got your hand up.
Yes, under other renewable low carbon technologies.
Mute, I'm afraid, I think.
Oh no, is that?
You are, you're back.
Okay, good. Under other renewable low carbon technologies on page 145, I would like to remove the reference to pumped storage hydroelectricity.
Right.
And that is in line with the fact that pumped storage hydroelectricity is excluded as a energy storage technology, which local authorities will provide planning permission to in the Infrastructure Planning Electricity Storage Facilities Order of 2020.
So it slipped through.
Yeah.
Okay. And has anybody got any comments to make on the removal of that? I'm suspecting it's quite a niche subject. Okay. Well, if the council did want to submit a main modification on that, that would be fine. Okay. Thank you. So that concludes the questions that I have for matter 3. Does anybody else have anything they wish to raise? No? Okay, thank you. So we are, many of us are going to be in matter 4 transport this afternoon, but for I'd just like to thank everybody who's been involved in the hearings this morning, particularly those who aren't going to be involved in matter 4 this afternoon. So without further ado, the hearing's now adjourned and I will see some of you at 2 o'clock. Thank you very much.
Thank you, madam.
Cheers. Bye-bye.
Good afternoon. We'll be starting shortly. I've just noticed that Kath Aylward's coming to the meeting. Are you able to confirm whether it is Kath or whether it is Mark who signed in differently, please?
It's Mark Aylward. I'm sorry. I don't know.
Right. I was just checking. You know, if you want to use your weekend name, that's fine by me. But yeah, if you wouldn't mind, just change it. I just wanted to just double check.
Yeah,
so if
fine.
you could just, do you know how to change it?
I'm working it out now. I think you.
Right. If you click on participants, it'll bring up a list on the right. If you just hover on your name, that's it. You've done, you've done it.
Yeah. Thank you.
Brilliant. Thanks a lot. Thank you.
Thank you. Bye.
The inspector is just about to join the meeting. She's already joined. Can I ask that you turn your cameras on, please?
Good afternoon. The time's 2 o'clock and the hearing is resumed. Can everybody hear me? Yep, I'm not seeing any shaking heads there. Okay, thank you. So this hearing forms part of the examination of the Climate Emergency Review Lancaster District of the Lancaster District Strategic Policies and Land Allocation Development Plan document and the accompanying Development Management Development Plan document. My name's Ms. Joanna Gilbert and I'm the inspector appointed by the Secretary of State to conduct this examination and to report to the council in due course. I think all of you were present this morning in terms of participants, but I'll just ask the council again if there's anybody new to this afternoon's session. So I'll just hand over to Mr. Brophy to introduce anybody from the council.
Yes, thank you. We do have another planning officer joining us
this afternoon to help out in particular with transport, and it's Richard Camp.
Thank you.
Good afternoon.
Hello, Mr. Camp.
Good afternoon.
Good afternoon. Okay, so just in terms of how it will work this afternoon, just for the benefit of Mr. Camp, so you can choose to keep your video off if you want to whilst you're not speaking, but if you are speaking, please turn your audio and your video on. And if you do wish to speak when you hear something being said by another participant, if you just put your hand up and I will turn to you in due course once the previous person is finished. Okay, so unless anybody feels strongly, they don't have to listen to me say the same things that I said this morning about how the examination will run. So it's my intention to get on, turn to matter 4 straight away. And in matter 4, for which the issue is whether the policies relating to transport are positively prepared, justified, effective and consistent with national policy, I asked a number of questions in my matters issues in questions about matter 4, and that started off with policy T2, which is in the part 1 local plan. So if we perhaps start with that first of all. Now that policy is amended to refer to developing the cycling and walking network, and can I just ask, first of all, whether what secure cycle parking would consist of in terms of policy T2, and whether there's flexibility by not defining this clearly. If I can ask the council that first of all.
Yes, I can refer to our response. Essentially, secure, it would basically refer to LTN 120, which is the DFT's guidance on cycling infrastructure. And secure, by their definition, is cycle parking that's not open to the passing public. So basically a lockable sort of compound, or a lockable shed, in essence, is kind of usually what it sort of consists of. So within the context of policy T2, talk about cycle networks. So there could be opportunities or occasions when on the network you would sort of look for secure cycling. It'd probably be with respect to like large developments, say it's like tourism sort of developments, or sort of new sort of redevelopments of retail areas, or I'm just thinking of the Canal Quarter in the city centre regeneration area, could be associated with the Eden project in Morecambe. So yeah, in respect of policy T2, where we're talking about the wider network, it's kind of be sort of situations like that.
Okay, thank you very much. Has anybody else got any points they want to raise with regard to policy T2 specifically? No. So if we move on to questions on policy T4, which is policy again in the Part 1 plan, and it deals with public transport corridors. Some of the policy remains the same, and there's an insertion of an additional paragraph in the middle of the policy and some changes to one of the latter paragraphs of the policy. So just in terms of policy T4, I asked a few questions in my matters, issues and questions. Are the aims of policy T4 deliverable, and would the policy be effective? And this is with particular reference to the risk of public transport operators not implementing additional services. And that's to the council, please. Yes.
I mean, basically, the approach that's been taken with the policy is to base it on existing practice. So over recent years, there's been a number of planning applications on the periphery of Lancaster where public transport can be lacking, particularly away from the A6 corridor. So in their highways responses, the County Council consider a range of factors, such as the scale of the proposal, the existing provision of bus services in the area, the site's location relative to employment and service centres, and the opportunity for other sustainable modes of travel. So requests from the County Council to the local planning authority are not made in every case, but only where there are significant levels of traffic being generated and where there are deficiencies in existing provision. So basically the wording that's gone into that policy just reflects, is basically consolidating existing practice to sort of basically provide a better, a more positively prepared policy T4. I do have a couple of examples I can share with you of where contributions in section 106s have been agreed. So I've kind of taken two extremes just to show that this isn't a policy to be applied to every single application. It's where there are significant highways issues and where there are deficiencies in the services. So the first example is planning reference 20/01145/FUL. So it's an application for the redevelopment of the Loon Industrial Estate located on the western edge of the city. So it was considered likely to generate significant levels of traffic and is also located in an area with no bus service. So in that case, the County Council made a request and it's been subsequently taken forward by the local planning authority through a section 106 agreement. And that's for a sum of £500,000 for the provision of a new service to that part of Lancaster. And then by way of contrast, there's planning reference 19/00332/OUT, and it's an outline application for 95 dwellings on land at Scotforth Road in South Lancaster. So Scotforth Road lies, well, it is a key transport corridor, public transport corridor serving the university. So it already has a really good bus service as it is. And obviously it's a site that would generate significant levels of traffic movement, but in that case, the section 106 agreement didn't include any request or any funding for improvements to the existing service. I think there was funding just to relocate a bus stop, but that was it. So yeah, just to make the point that, you know, it will be applied on a case-by-case basis.
Okay, thank you. And in terms of that case by case basis, so that would be looking at any existing deficiencies, and those deficiencies could be the route itself and the frequency, but it could also be the location of things like bus stops as well.
Yeah, it can be, yeah. I mean, we talk
Okay.
about in the policy about high quality services as well. So, yeah.
Okay, thank you. Mr. Aylward, I see you've got your hand up, and then Mr. Dauber after that, please.
Thank you, Ma'am. Of course, we understand that there'll be instances where there'll be substantial developments that would justify 106 contributions for transport mitigations, but they are supposed to be to mitigate impacts rather than necessarily simply be a product of the scale of development, because it could be the case that a certain length of highway has lots of latent capacity that will be dealt with through an analysis. And of course, as you're aware, it's not the purpose of planning obligations to deal with an existing deficiency. So I think for our purposes, we've suggested some revised wording in our representations, and they're essentially to add in reference to where those significant movements would result in severe impact. We think that's the test, is the extent of impact, rather than necessarily the quantum of traffic generation, because there'll similarly be examples where a road's under stress in some sense, where a much smaller degree of traffic increase could result in a severe impact. We think it's the impact should be the test, not the quantum of traffic in the first instance.
Thank you. Mr. Dauber?
Thank you, ma'am. It was interesting hearing Mr. Camp's discussion about these things already being requested. You'll have seen within our representations and our hearing statement, we cite a specific example, which is the Story Homes Grab Lane application. The reference numbers within our hearing statement, I won't repeat it here. So that's a site for residential development. The request came from Lancashire County Council for a £500,000 contribution towards supporting, in this case, an existing bus service. So I guess that is the grey area that we need to pick up on, where there is obviously Mr. Camp reference of black and white examples, where I think it was the Loon Business Park that he referenced, where there is no bus service. So obviously that's an obvious case where it's deficient because it doesn't exist. And then the other development, I think, was Scotworth Road in South Lancaster. That is one that is on an identified high frequency route. So it's very clear that there is no deficiency. What's less clear from the policy wording as is how do you define those grey areas? What is deficient if there is an existing bus service? What would make that existing bus service deficient in some way? So I guess that's what we're grappling with in terms of definitions. It wouldn't be me making a comment without saying viability, which we'll come on to on Friday again. But the viability assessment at paragraph 7.10 states that there are some allowances for section 106, where these may be sought for travel planning, public transport or highways. These are not routinely sought by council, so there's limited evidence on which to base figures. That's in terms of working out what is required to take account of in terms of viability. Our concern is that the application of this policy has the potential to increase the rate that these public transport requests are being made, and therefore they would potentially become more commonplace and therefore would need to figure in the viability assessment, especially if it sums of the amount that are being discussed here. There's another application that I'm actually agent for at Quernmore Road in Lancaster. It's for 116 houses, and the amount being requested at the moment is about £250,000. So it's a lot of money considering the size of the development, and it would make sense to consider that in viability terms, in terms of justifying that in evidence. Thank you.
Thank you. Mr. Berend next.
Good afternoon, ma'am. In terms of I support what Mr. Dorber has just said, but I think there's an additional point we'd like to raise is in terms of, I suppose it's the consideration on a case-by-case basis, and I think what Mr. Camp has set out is a consideration of that, and on consideration of a far wider set of issues than just the public transport. It is about what the type of development, the likely impact arising from that scheme in terms of the impact in terms of where it is in terms of local services and as well as places of work. So I think there is a far more detailed and nuanced consideration going on by the council and the Highways Authority. And I think that needs to be reflected really within the policy. It's not just about, clearly it's not just about a deficient service, it's about the nature of the development that's coming forward as well, and how those interact with the with the service. So I think it is, how do you put across that it will be considered on that case-by-case basis on a far wider set of circumstances than just, is that service deficient? And then that also relates to the point Mr. Dorber was making in terms of what is deficient and what is deficient in relation to that development. So I think there's far more interplay that needs to be reflected, I think, within the policy.
Thank you, Mr. Brown. And Mr. Nellist.
Thank you, Mum. I've just heard what Mr. Barron has said there, and I was going to make a very similar point. Yeah, I appreciate what Mr. Camp said in terms of the way the council will consider this, but I think the policy just needs to be a bit clearer that is the case. The wording within the policy at the moment that relates to case-by-case basis appears to relate to just the commencement of services and the duration of support, rather than whether those services are actually necessary. The last point we made in our matter paper, just draw attention to it, is often we find that even with a willing developer and local authority, the service providers just are not willing to provide new services, so it's not always possible. And again, the way the policy is worded, it probably just it should be a little more clearer to allow for that case-by-case consideration.
Thank you. Would the council like to respond on all that they've heard from Mr. Aylward, Mr. Dorber, Mr. Barron, and Mr. Nellist?
Yes, on the matter of how you define what deficiency is, I think, I mean, I've read the response and the proposal to refer to the word severe. I mean, the concern is with that is how you define severe. I mean, it's obviously in NPPF as like a defining sort of cut-off as to when development is inappropriate or should be refused, but it's quite unusual for the Highways Authority to kind of define something as severe, and I think if we did put that word in there, we would be going backwards to where we are actually now, and what as in response to the climate emergency, what we want to do to go forward. I mean, I take the points on viability, and I think that was discussed on Friday, but we want to take the best practice that's happening now and sort of consolidate that into these policies. So I think I think we do, deficiency, and moving on to the other point is about how you define deficiencies and whether we need to change the wording to say that it is on a case-by-case basis. But I suppose within the wording there are two elements. There's whether it's significant in the first place, which is a judgment for the Highways Authority based on a range of factors that will include existing, how well it's linked to sort of services. We'll look at whether there are existing cycling infrastructure. They'll look at the existing bus services. So they will look at all these issues in the round. And so, yeah, I think there's sufficient flexibility there. There's two key words, whether it's significant and whether there is a deficiency.
Thank you. Mr. Tucker. think you're still on mute.
Apologies, sorry, my mouse has disappeared from my screen for reasons that I can't explain, I'm not sure. Can I just, further to what Mr. Camp has just said, particularly with regard to introducing the term severe within policy, there's a problem with that, which is that the test isn't severe. The test is residual cumulative impacts are severe. That's the test from paragraph 111 from the framework. And you have to read that paragraph, residual cumulative impacts, in the light of the preceding paragraphs, paragraph 110, which sets out a number of different things. And I draw attention particularly to A, that there's got to be a demonstration that appropriate opportunities to promote sustainable transport modes essentially have been taken up. And then D, that significant impacts can be cost effectively mitigated to an acceptable degree. So it's not just severity, and to introduce severity as part of the testing policy is problematical unless you've got those earlier stages. What the policy seeks to do is essentially to take A, paragraph 110A into account, and to do so in the light of both A and D, rather than trying to replicate what national guidance says. So I'm just flagging up that severity of itself is problematical if one starts to introduce that in policy.
Thank you. Mr. Elwood.
Thank you, Ma'am. That's very helpful, Mr. Tucker there. I think from our perspective, we think that a reference to impact is important. And I understand the point about whether you refer to the word severe or another word that's less definitional. But then also going back to a point that Mr. Camp made as a response to another, my understanding has been in practice is that you would only ordinarily impose conditions or obligations to make an otherwise unacceptable development acceptable. So I think there is an appropriate reference, and in terms of highways impact, it's the phrase that Mr. Tucker just used perfectly. It's a degree of impact, relative to a context. So, but the key word there in our view is impact. So I'm fairly clear in my view that the T4 would only be sound if it has reference to an impact it was seeking to mitigate. Thank you.
Thank you. Mr. Camp.
Yeah, I'd just like to point you to paragraph 105 of the MPPF. So that says significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. So, basically it's not just mitigating the impacts or making some, it's also about providing development that actually offers a choice of modes of transport.
Thank you. Mr. Dauber.
Thank you, ma'am. I think it is an important paragraph 105 that Mr. Camp points out. It goes back to my earlier point where unless it's a black and white scenario where you've got an entirely absent bus service where it's clearly deficient, or you've got a high frequency one, it's hard to tell from the word in the policy at the moment whether developers looking to bring forward a site in Lancaster will be liable to make contributions towards bus service based on the policy wording. I appreciate that they are being requested to do that now, which begs the question: do you need this in the policy if it's happening anyway? But yeah, I think just a bit more explanation. It could be in the policy or the explanatory text about what the council will consider as deficient and what they would consider a high frequency would be beneficial particularly for allocations such as my clients at Grab Lane, where there is a bus service which we would consider of a good frequency, but they're being asked for contributions towards supporting that. It seems that this policy isn't helping clarify that situation. Thank you.
Thank you. Mr. Camp, you've got your hand up. I also note that there is the suggested modification that the council's put forward in response to my question 4.6, which sets out frequent services and key public transport corridors, but I'll hand over to you on that. I'm afraid you're on mute, Mr. Camp.
Yeah, that was going to be my point. Yeah, because in clarifying what, in response to that question, in sort of discussion with the county council, they've kind of confirmed what they see as a frequent bus service. And so basically they're looking at high frequency services on the main key corridors, and elsewhere they're looking for services of 2 an hour minimum. So I think that provides some basis or some sort of something for development elsewhere that Mr. Dorber is referring to, give some sort of guidance.
So that would assist in both dealing with deficiencies and in confirming what a frequent service was considered to be. Yeah,
I would have thought so. It's a starting point, isn't it? I suppose that in any application there'll be pre-application inquiries with the county council, and then obviously can be explored through that. But beyond that, I mean, we could get some additional text from the county council to explain the parameters of how they assess. I mean, that could be something that we look into.
Okay, so if the council could take away that, and I recognise you've already done some work in the statement in terms of the high quality, the frequent services, but perhaps you could take away that sort of deficiency versus frequent services and come up with some supporting text to explain that. I think that would help the situation. Okay, thank you. Now, it was clarified to me yesterday that, and I just wanted to double check this. So I asked about the difference between a bus rapid transit system and the Better Buses scheme. And I was told yesterday that this was simply a difference in name rather than any other. But the council's response to question 4.7 appears to me to indicate that it is slightly more than a name in difference. Could you just explain what the situation is there, Mr. Camp? Or I can see Mr. Tucker's hands up. Perhaps Mr. Tucker first.
Yeah, can I start off and then Mr. Camp can give you the details?
Absolutely.
Just to clarify, yesterday's response, having taken instructions, was in error. It's not just a straight change of name. So it's not just a rebranding of the same product. However, it's important to know what the differences between the two are. So it's dealing with the same sort of corridor, but it's not dealing with the original rapid transport isn't quite a rapid transport as you might have thought from different locations. So, for example, picking an example of Leeds, where you've got the central reservation that's been dug up and you've got the buses that operate through a central reserved reservation. If there had been any element of that, it would have been very limited. So it's a package of measures to improve bus connectivity and bus priority along the particular routes. The change involves a different package, but it's a different package to the same consequences, which is why there was a misapprehension in responding to you yesterday. So Mr. Camp can explain the details of it, but essentially it's a different package of bus priority measures. And to call the original one a rapid reach transit search, to be blunt, was possibly a little bit overly optimistic on the authors of who chose that particular title. So it's not as if it's a downgrading from something super duper down to something far less. It's half a step down rather than about 3 staircases down, if that makes any sense.
Okay, thank you. Mr. Camp?
I can only add, BRT technically is where they have a segregated bus lane. So I think along the A6 corridor, I think that just from a physical infrastructure point of view, it's something they couldn't accommodate. So I think they had to, move away from the BRT and call it Better Buses. So that's essentially, it's a physical infrastructure thing more than anything else. So
So to ally it with something that I'm more familiar with, Cambridge has a guided busway. Elements of the guided busway occur off-road on a guided route, and they are extremely fast, and then it enters the city centre and it goes off guide because there is no option in terms of space to actually allow that to remain on a segregated route. And so it's a frequent service, but it is significantly different in its activity inside the city than it is outside.
Yeah, that's essentially it. Yeah.
Okay, fine. Okay. Thank you. That's good to clarify that. Okay. Any more points on public transport services from any of the participants on policy T4? Yeah. Okay. Just in terms of the 400-metre walking distance that was mentioned, I think that there's, so paragraph 14, new paragraph 14, it refers to a reasonable safe walking distance considered to be 400 metres on average 5 minutes. And the council's responded on my question about the definition. Is there any need for flexibility of application of the walking distance dependent upon specific local conditions? So something like topography or safety?
I think, in reality, there would be. But we're reluctant to kind of change the 400 metres because it is something that's commonly used amongst highways authorities. So, be reluctant to change it. I mean, also, I'll draw your attention to the fact that that word, the 400 metres, doesn't appear in the policy itself. So the policy itself is, safe walking and cycle travel distance to all parts of development. So, we consider that no change is necessary.
Thank you. I can see Mr. Barrett's hand up.
Yes, I think this was something we raised in our representation in our hearing statement. So I think it's recognised that it is in the supporting text, so therefore it isn't a policy ad. But I do think it's to apply it directly. I think to have some wording within the supporting text saying that about a flexibility with regard to the topography and other elements that we raise and Mr. Camp has acknowledged would be helpful, just because otherwise it can be seen as a fixed number by decision makers, and actually recognising that it is a flexible figure would be helpful, I think, in terms of the decision maker, recognising that it is in supporting text and obviously isn't a policy requirement as such.
Okay, thank you. I think I understand where both of you are coming from, but Mr. Camp, did you want to respond to Mr. Barrett at all?
No.
No. Okay, thank you. Anything further on T4 before we move on? No. Okay. So I did ask a question about policy SP10 in relation to T4 and T2, I think. Anything on SP10, which is improving transport connectivity? Just I just had one question to ask on it, which was, what's the status of Lancashire County Council's movement strategy?
Yeah, I'll answer that. It's something that the County Council continues to work on. So they did do consultation some time ago now, where they were narrowing down options, and we're awaiting another round of consultation before that is concluded. But they are working on it, definitely, in the background, and activity there is happening as they narrow down their options.
Thank you, Mr. Brophy. Okay, anything more on SP10? No. And I did also make reference to SG12 in my matters, issues and questions. I don't have anything further to ask on SG12, but just allowing the opportunity for any participants if they've made comments on SG12 before. No. Okay. And then moving to policy changing plan to part 2 and DM31, which deals with air quality management and pollution. Now, the policy itself isn't proposed to have any changes to it, but there are a number of additions suggested to the supporting text. And just like to ask the council what the situation is in terms of progress with the Lancaster Air Quality Action Plan, please.
It's currently being reviewed, so that's something that's done by officers in another service within the council. And yeah, there is work that's currently happening on it with engagement with Lancashire County Council. But as to a timetable, I don't have one.
Okay, it's under development. Yeah. Okay, thank you. And in terms of new paragraph 35 in the supporting text, yes, new paragraph 35, it goes over the page. So there's reference made there to World Health Organization air quality standards or guidelines. Is it appropriate to be referring to those? Does the council consider it's appropriate to be referring to those?
Can we promise to get back to you on that particular point? I may need to refer to a colleague in our environmental health department about the source of those references.
Okay, I think this part of the reason I asked this question might have stemmed from one of the hearing statements that's been produced. Let me just double check. Well, I'll leave it with you for now, and if perhaps you can come back to me. Mr. Nellist, I think actually Mr. Elwood and Mr. Nellist have both put their hands up, so I'm not sure which one of you came first. I'll go in alphabetical order, Mr. Elwood first, and then I'll come to Mr. Tucker after.
Thank you. I think Mr. Nellis beat me to the punch there, but thank you very much. The comments we've made about para 9.35 particularly is the reference not to the WHO objectives in terms of the way they cross-reference, but because they refer to PM2.5 and PM10 levels, and we're not clear of the specific relevance to Lancaster because the AQMA exceedances here are to do with nitrogen dioxide emissions, not PM2.5 and PM10. So we just query that particularly as to why they need to be referenced here. And there's also a more pedantic point about para 9.22 because it refers to the kind of key changes to now refer to developments that are close to an AQMA rather than those that are within an AQMA. It doesn't actually define what close means, and that just, to our mind, just breeds a opportunity for vagueness. It would be better to be precise. I mean, there's already, as you know, that for a more substantive development, if it was an EIA development, the cumulative effects, you could more reasonably have reference to developments that would have an effect in AQMA that might well be further afield. But I think in terms of, because this is appears to be being proposed at a more general level, not to those strategic developments, it does. I think without that precision, it's going to, in reality, mean applicants are going to be producing air quality assessments that don't really take sort of the planning authority very far.
Thank you.
Thank you.
Thank you, Mr. Elwood. Mr. Nellist.
Thank you, ma'am. Yeah, I was put my hand up just to sort of assist. It's our matters paper. I think we'd probably make a similar point to Mr. Elwood, given what I've just heard him say. So it's just to assist there. I think it was a point on the legislative status of the World Health Organization guidelines.
Okay, thank you. Mr. Tucker.
Yes, madam. Just a couple of points. The first of which is, I think the reason that the WHO guidelines are being referenced there is because the WHO guidelines are referenced in the National Clean Air Strategy. And I think that appears from the preceding couple of lines to the ones that, madam, you've made reference to. So I'm pretty sure that's why it's there, but we'll double check it behind the scenes. The second of which is, what the sentence requires is consideration of those. It doesn't require conformity to those. So ultimately, I apprehend that when we come back, it will be that it's a factor that has to be borne in mind because of that reason. And I only raised my hand out of the hope that I'm right and that it's helpful, but we'll double check.
And in terms of development close to an AQMA,
I think that's
Mr. Elwood just made.
Yeah, that I'm pretty sure is also intended to catch the fact that you may have development not in an AQMA, but which results in traffic going into an AQMA, which will be much traffic dotted around the principal urban area, and that's what's being sought. So essentially, it's a matter of judgment in any given circumstances. So what may be close for one development may not give rise to traffic going into an AQMA, but others may. So it's seeking to identify, I suspect, that impact. But Mr. Brophy will tell me if I'm wrong in that regard. So the idea is keep it flexible so that you can pick that up.
Okay. So what might be worthwhile, given we don't appear to have an air quality specialist with us today, is if Mr. Brophy and his team could work with air quality colleagues, perhaps produce a note, but have discussed the content of that note with Mr. Nellist and Mr. Elwood, given that they've got particular interests from the perspective of their respective clients.
We'll make sure that's done, madam.
Before the note comes back to me.
Yes, madam.
Yep.
We'll make sure that's done. Thank you.
Okay, thank you. Just note down. And helpfully they can watch the live stream. They can watch the recording if they wish to try and understand what it was we were discussing in the first place.
Yes.
Okay, great. Fine. Don't think we're going to get much further with air quality, but there was a modification that was just needed to the supporting text, I think, in terms of reference to the Environment Act rather than the bill. Which I think the council had picked up on. So if that modification could be done, that would be helpful. Was there anything else on policy DM31? No. Okay. So if we move forward to DM60, get back into more substantive transport points. Okay. So policy DM60 deals with enhancing accessibility and transport linkages, and this is a policy which is an existing policy, and it's got a number of amendments in it relating to convenient access for all. So I asked questions about how accessibility is referred to in my matters, issues and questions. I think that was question 412. So are the policies and supporting text of the plans consistent in how accessibility is referred to? Perhaps I could have been clearer on it, and because it's, I suppose my concern relates particularly to disability here. I've read through quite a number of different parts of the plan where I have read different things about how people who are disabled are referred to, about what different levels of disability are referred to as. And I just think that overall, the way that it's expressed differently in different places actually will not make it particularly clear to the end users of the plan. So I could pull out quite a lot of examples, but in the Part 1 plan, there's a number of examples in the supporting text and in policy T2. In the Part 2 plan, there are references in DM29, which I talked about this morning, where I talked about criterion 8 and criteria 10 and 13 and how they all work together. But then we've also got more references here in DM60 at criterion 2 and then moving into DM61. So I'm not usually prone to going and Googling things because inspectors shouldn't do that. But I did. I failed to resist the temptation, and I went and Googled adaptive mobility. And it didn't really teach me very much about what adaptive mobility was. Now, I see in some places that it's basically people using wheelchairs, mobility scooters and the like, perhaps walking sticks, crutches, and they may find it more difficult to use particular pedestrian routes, or they may need slightly wider pedestrian routes, for example, to allow them to get in and around places if they're in a mobility scooter, or in a wheelchair. But the lack of consistency of approach really just made it very unclear in a number of places. So what I would suggest is the council looks through all of the policies and tries to draw together what it is they're aiming to achieve, perhaps use as a glossary item to sort it out. That would probably be the quickest way of doing it. But yeah, I think that was all I wanted to really say on that point, and I don't know what the council's view is on that.
Yeah, thank you for that. I think probably a lot of the policies have been authored over a different time frame by different authors, and references to definitions around accessibility are prone to evolution. We will double check them and seek that consistency that you rightly advise should be present.
Yeah, and I don't know how the council operates. Some councils have an officer who has a specific role in terms of advising on disability. Some councils have a panel which deals with issues such as disabled access in planning applications and so on. There can be very differing views as to appropriate terminology to use. And so if you do have that scope, it might be sensible to approach somebody for advice, because it can be difficult to navigate the terminology.
Thank you.
But, yes, I'll leave that one with you to pick up. And then just in terms of going back to DM60 itself. So is it necessary to propose the changes to DM60 criterion 2, given that criterion 3 actually refers to buildings and places being easily accessible in the first instance anyway?
Yes, I think we did address that in our response. Just to tidy up those, yeah.
Yeah, so if you could do a modification to that, yeah, okay, and that's fine. Sorry, I'm missing pages in my notes. And then moving on to criterion 8 of policy DM60. So this dealt with paragraph 110 of the framework. So is the council also happy to do a modification in that respect as well?
Yeah, we proposed that.
Yeah.
Okay. Response, yes.
So a modification, and that's referring to paragraph 110B.
Yeah.
Yeah. Okay. Thank you. Anything more from any of the participants on policy DM60? No? Okay. So moving on to DM61, which is prioritising walking and cycling. And that policy is again being proposed for amendment in a few areas, and then supporting text is proposed for amendment. So the final paragraph of the walking section on policy DM61. So this was my question for 16. The council's going to put forward a modification on that to refer to the additional criterion on accessibility. Is that the case?
Yeah, that's right.
Yeah. Okay. So if the council can do that, please, and add that to the table of modifications. And then my question for 17 about the local transport, the LTN 120. So LTN 120 is referred to on page 171. Design of new infrastructure should be of high quality and in accordance with local transport note 120, cycle infrastructure design. So just in terms of flexibility of application of that, could the council just take me through how that will be applied, please?
Yes, ultimately, LTM 120 is kind of sort of now national guidance being produced by DFT. It's something that the local highways authority will be increasingly referring to in their responses on planning applications. So really, the inclusion of it in the policy is to reflect sort of that growing agenda of active travel. In terms of how it's applied, I mean, basically, we're not the highways authority ultimately. So what we would seek to do is the general principles that are in LTM 120. So it's about creating places that encourage walking and cycling. We won't get involved in the specifics of, the surfacing and materials and the details of design. Obviously, that's down to the highways authority. But it's those general principles we'd be sort of seeking to pursue through the planning applications. So in terms of, it's about creating those places where walking and cycling is sort of encouraged, and also developing networks within sites and connecting to the broader network. So, connecting to the city centre and places of work, et cetera, et cetera. So that's the way I see that functioning. As I say, we're not the highways authority. We won't necessarily be responding in terms of the detail. So, just in terms of how it applies, that's the way I see it applying.
Okay. Anything else from any other participants on policy DM61? No? Okay, so we move on to the policy that I suspect everybody's been waiting for, which is policy DM62, which deals with vehicle parking provision and electric vehicle charging points. So this is a policy that already existed, but has had a fair amount of text added to it in terms of electric vehicle charging, and then there are additional changes which are proposed in the supporting text. So just in terms of policy DM62, could the council confirm their answer in terms of whether the policy is positively prepared, justified, effective, and consistent with national policy.
Yes, thank you. I'm going to focus on the EV charging. If you'd like me to expand on the other sections of the policy, I'm happy to do that as well.
I think if we make a start on EV charging, that's fine. Thank you.
Okay. So brilliant. So the government in 2020 announced plans to accelerate plans for a greener future. And you'll notice with that there will be the phase out of electric vehicles and diesel cars and vans by 2030, with all new cars and vans to be fully zero emission from the tailpipe by 2035. The government sees this transition. Transport emissions represent about 25% of UK emissions, and UK green financing is focused primarily on reducing the emissions of transportation. EV chargers are seen as, or EV cars are one of the primary ways to deal with residual transport emissions, and it's really important that we have the appropriate infrastructure for them. The government has held a consultation 2019 on electric vehicle charge points, which has resulted in the Part S of the building regulations. So it's important to note is that the preparation of this policy started prior to the coming in force of Part S. However, it still is considered to be effective as it goes beyond the building regulations and really focuses on the need to address the climate emergency declaration and provide for equitable and consistent provision of electric vehicle chargers. The paragraph 107 of the framework is clear that policies should take into account the need to ensure an adequate provision of spaces for charging plug-in and other ultra-low emission vehicles. And they're also a key consideration in the National Design Guide. So it's consistent with national policy. The sustainability appraisal highlighted that changes to policy DM 62 will have a positive effect on air quality and help to support rapid shifts towards the use of electric vehicles, reducing roadside emissions. I think what's important also to note is that policy DM 62 has been prepared in collaboration with other departments within the council, including environmental health, public realm, and conservation. But critically, in terms of many of the issues highlighted in the hearing statements, it's also been part of wider consultation at Regulation 18 and Regulation 19 with organizations such as Lancaster County Council and critically our district, our DNO, ENW, our distribution network operator, Electricity Northwest. So would you like me to expand any more on that, or is that sufficient for now?
That's fine for now, thank you. So just in terms of forms of development that the policy would be applicable to. So the initial text, so we're on page 174 of my printed copy, which says all new development and changes of use with associated car parking shall provide as a minimum. And then it goes on to refer to dwellings. So could you just confirm to me what forms of development the policy would be applicable to?
So as stated in the policy, it applies to all new development. There's two different criteria in there. You'll see that there's one charging unit for each dwelling with an associated space. Associated space is then expanded on in the supporting text and then in the forthcoming SPD, which has been subject to pre-regulation 12 consultation. And then criterion 2 provides further clarification for when criterion 1 doesn't apply. So 20% of communal parking spaces. So that would be either in residential or commercial development.
Does the council consider that sufficiently clear at the moment? Because my first reading of it was, well, which one does it apply to? You know, if I was trying to deliver a development, well, I'm not delivering any housing, what applies to me?
So the council does see that as clear, however, could go back and consider a modification to the effect that makes that a bit clearer how that applies.
Mm-hmm. Okay, and in terms of associated space, is that dealt with very similarly to building regs to Part S?
That is dealt with similarly to Part S, and it's expanded on quite a lot in the SPD, which was subject to pre-Reg 12 consultation.
Okay, thank you. So in terms of going beyond Part S, do you consider that, why does the council consider that it's appropriate to go beyond Part S?
So again, this was prepared in consultation with other bodies, and we see that the Northwest has the second lowest density of EV chargers in England, and it's very important to supply or to support the transition to them. EWL's customer choice surveys have suggested that people's lack of access to EV chargers kind of makes them less or more hesitant to adapt to EV vehicles. And so increasing the amount of electric vehicle charge points in an area of the country which nationally is recognized as having a low density of them is critical in order to support the transition towards decarbonized travel.
Thank you. And are there any contradictions between Part S and what is being proposed in policy DM62? If you were a general house builder or developer who worked across the country, how straightforward would you find DM62 to use?
DM62 is quite straightforward, and as we've noted, goes above the building regulations. So meeting the criterion of DM62 will meet the minimum set out requirements of Part S of the building regulations.
Okay. Any views from any participants? Any questions from any participants on this point? Mr. Barrett.
Yes, sorry, Mark. I have. I don't know whether you can hear, but someone seems to be drilling in the room above. So apologies. I will try and speak up. They're not trying to get to me and make me shut up. Down in London, so a long way from Lancaster. Sorry, I digress. In terms of the council approach, I think what I can say is concern is I think some of the concerns you're raising in terms of the difference between what the council are asking for and what building regulations, the confusion that's just inevitably going to rise, and also what significant differences there are between what the council are asking and that. And I think what the building regulations are setting out is that every home with an associated space will be required to have that. And that is seemingly what the council are seeking to address within the policy. So, and I think then there's also that difference between what the council is saying in terms of dwellings and residential development, and also the split within the building regulations between different types of development as well. I think what the building regulations offer is far more clarity as to what is required than the council are offering within this policy, which isn't clear in terms of what is required and isn't as clear as the building regulations. It offers that national clarity. I don't think the council should be going, we rehearsed this morning, Ma'am, about going beyond building regulations and the requirements and the ability for local authorities to go beyond with regard to technical standards, given that the technical standards, the optional technical standards are set out in PPG and the requirements, and electric vehicle charging is outside of that. Granted, this is coming outside of that period, but there has been no changes to say that the council should be able to go beyond in terms of technical standards with regard to electric vehicle charging. And I think the most sensible and appropriate approach is to remove the policy and rely on building regulations moving forward. I think that is the most appropriate way forward with this policy, Ma'am. I think elsewhere it just provides, it's a lack of clarity, there's confusion, and it's not an appropriate way forward. Thank you, Ma'am.
Thank you. I think it was Mr. Dorber next.
Thank you, Ma'am. I won't rehearse the points Mr. Behrend has just said. Our principal issue was in terms of the principle of using renewable and or low carbon energy generated on site to power the EV charging points provided. So we heard earlier in terms of policy DM 30.A, the council are seeking to pursue that all development adheres to the energy hierarchy. That puts a further low priority in terms of design considerations to the incorporation of renewable and low carbon energy within development. And in this case, we're particularly focused on residential development. However, to power the amount of EV charging points required by the policy, it would seem there would be a significant feature of the design of residential schemes would be this renewable and low carbon energy generation facilities, and that appears to be a contradiction. I appreciate that there is a wherever possible caveat in this policy, but the question is, given that there's an apparent contradiction between the two policies, is it in fact desirable to have this at all? Rather, should the council rely on the decarbonisation of the grid rather than site-specific renewable energy generation to power that EV charging? Also, again, banging the viability drum, there doesn't seem to be a particular consideration of the requirement for renewable low carbon energy generation, specifically in terms of EV charging points, in terms of the specification of EV charging that the viability assessment is considered. So again, one for Friday, probably. Thank you.
Thank you, Mr. Dauber. Mr. Elwood.
Yeah, thank you, Ma'am. Yeah, so obviously, you know, the V word's on our mind as well, but we'll leave that until Friday. In other terms, so there was reference to whether or not the policy goes above and beyond the building regs. So obviously it does, and I think the council agrees to that point already. What the building regs did, Part S, the government produced an impact assessment, and what that appeared to show from my reading was that the key constraint to future supply was going to be the excessive costs involved in having to retrofit the EV charging. So there was certainly a preference there to increase the amount of provision provided for what we call often called as passive facilities, rather than the active facilities. So we see that the council here are suggesting all spaces to have at least passive facilities, and obviously the government's assessment was 20%. I think from our perspective as a developer, we have no real issue with a more substantial proportion of passive facilities, because they're quite straightforward to put in at day one, and we entirely understand the benefits of that over and above retrofitting. What we do have issues with is the amount of active charging being requested at day one, because that doesn't align with the government's impact assessment in terms of what actually dictates supply and demand later. And there was another point as well, which was about, when we move on to, again, we can, because there's all these policies are interconnected, aren't they, to various degrees. The policies that relate to air quality, we can of course understand that in an air quality management area there might be a reasonable policy basis to seek additional measures for active travel, whether that's for bus services, cycling, or even EV charging points. So we can see perhaps that there might be a justification for a increased EV provision in air quality areas in accord with an air quality action plan, perhaps. But again, because a lot of the borough isn't AQMA, that's again why it shouldn't be applied on a blanket basis. So I think our key concern here is the extent of active provision required. Again, going back to the viability word, and because our clients' interests are predominantly commercial development, so the issues around sort of EV charging on every dwelling is different. In reality, if you were to seek this level of EV provision on an office park or an industrial facility or a retail park, it's really quite a significant power requirement for that development. There's a viability implication, but there's also, in reality, quite likely to be implications for having to produce substations. So, and again, there's no evidence of that's been referred to in the council's viability evidence, which we'll go through on Friday. But I think it's just the practical application of these policies, I don't think have really been considered enough. And again, when you look at the government's own impact assessments, they've taken what they see as a pragmatic view whilst being aspirational. This is very, very different. I think it is not sufficiently well considered. Thank you.
Thank you, Mr. Elwood. Mr. Barrett again.
Thank you, Mark. I did forget to raise one point in terms of the difference between the building regulations in terms of the cost cap that's included within the building regulations and not reflected within the council's policy. Obviously, again, there's a key part of building regulations in terms of determining what and what should be provided that doesn't seem to be considered or even factored into the council's considerations with regard to the application of the policy in terms of any flexibility, but also in terms of viability going forward. So I think it's those elements that the building regulations are a far more considered approach to this and provides a far more robust approach, I think, in terms of delivering improvements in EV charging. Thank you.
Thank you. Mr. Elwood, did you want to talk again?
No, that was a senior error. Sorry, I'll take my hand down now. Sorry.
Yeah, a legacy hand. Thank you, Mr. Elwood. Okay. Would the council like to respond to all that they've heard from Mr. Dauber, Mr. Elwood and Mr. Barrett?
Yes, thank you. So I'll just start at the top. In terms of the building regulations, again, the building regulations set out kind of minimum requirements, and the council is seeing it as effective and justified to go beyond the building regulations, again, because we have the second lowest density of EV chargers in the country, and it is critical that we support that transition to net zero transport in the region. The policy as it's set out is straightforward, and again in areas goes beyond the building regulations, so should not cause any issues with building regulations or going through passing inspection. We've addressed the lack of clarity and confusion, and we have taken on board that we're going to go away and look at particularly the transition between point 1 and point 2 so that it's clear how that applies to different developments. There was the comment about renewable energy and DM30A in the energy hierarchy. I'd just like to make it clear that DM30A in the energy hierarchy only applies to the regulated energy use of the building or that energy use which is covered in an SAP assessment or in Part L of the building regulations. It is quite clear that EV charging does not form part of the regulated energy use of the building. So any renewable energy that's provided to feed your electric chargers would be in addition to what you're doing for the energy hierarchy in DM30A. There is flexibility written into the policy in light of this, though, which says wherever possible, it should be provided through renewable or on a low carbon energy generated on site. We do not see it as appropriate as relying on the decarbonization of the grid. Again, the climate emergency declaration sets out for the district to become net zero by 2030. Decarbonization of the grid is not expected until 2035. That's 5 years later than the target date that we'd like to go to. Viability was brought up a few times, and again, that will be covered on Friday. I think what should be noticed is that there is headroom in the viability assessment for this policy. Again, passive facilities, I see the attractiveness of putting them in. However, let's just be clear that that is just the wiring and ducting and cabling for EV chargers. That doesn't actually deliver an EV charger for somebody to plug into and to use. So that's not actually helping meet those requirements of decarbonization of transport in the district. Air quality is, again, a reasonable thing to consider. There may be considerations for where it should even be deployed at a higher rate in AQMAs, but we also need to recognize that cars move. They may start in an AQMA or park in an AQMA, but they'll often come from outside of AQMAs into AQMAs. And so we need to have a way to make sure that that there's decarbonization of transport across areas, regardless of if it's an AQMA or not. And again, it's really important that we have a consistent approach to where the EV chargers are distributed, so that we make sure that regardless of where people are living or working, they are supported in their transition to electric vehicles. There is the question about the significant power requirement in substations. And then also the cost cap. The cost cap is reflected. I'm going to address that first. The cost cap is addressed in the forthcoming provision of electric vehicle charging infrastructure supplementary planning document, which was again subject to pre-regulation 12 consultation, during which we gathered early views, and the cost cap was in there, as well as the council's approach to flexibility. The council also outlined in that SPD the approach to flexibility in terms of grid capacity at a specific site, if there are indeed issues at that specific site related to grid issues. However, as I mentioned earlier, the council is a stakeholder with ENWL, and ENWL takes into their just make sure I give you the right term, into their future planning scenarios, the different requirements of different local planning authorities in their planning of the grid requirements. And they're particularly looking at the flexibility of the grid in terms of EV charging, battery storage, and renewables, which all kind of turn hand in hand with this policy. And again, where there is issues with the grid, the SPD sets out the council's approach to flexibility in terms of that. I hope if I've missed anybody's points, or is that sufficient?
There was the cost cap, there was the passive matters which we've dealt with. Just to go back through my scribbling. So there was the substation and the space requirements.
Yeah. So the substation is dealt with our. The other thing to note on that is the government has anticipated potential issues with grid power supply and substation capacity, and has issued into law the Electric Vehicle Smart Charge Points Regulations 2021, which came into force on the 30th of June of this year. And that ensures that charge points have smart functionality and manage the car charging.
Mr. Elwood has his hand up, so I'll go to him next and perhaps come back to you, Mr. Hart. Mr. Elwood.
Yes, thank you, ma'am. Our only real kind of point there in reply to Ms. Dart's comments there is in terms of this, the reference to the contribution that passive provision provides to the EV agenda. It's quite clear from the government's own impact assessments in terms of Part S of the building regs that they deemed that the provision, that the key constraint to providing space was the additional costs in relation to retrofitting. And so providing more passive spaces does, as I read it in the government's view, does provide a significant contribution towards the realisation of increasing EV parking in the marketplace. And if that wasn't the case, I don't really see why the policy as worded would suggest that all spaces have passive EV facilities anyway. There must be a view that having passive provision of facilities there is a benefit. And I've set out earlier on that from my client's perspective, we have no substantive issue with there being a significant amount of passive facilities there. Our issue is with the extent of active facilities, which we think is excessive. And as we'll go through on Friday, we don't think it's necessarily been tested from a viability perspective, particularly in terms of some typologies, but that's a matter for Friday. Thank you.
Thank you. Mr. Did you want to respond to anything Mr. Arwood's just said?
Yes, so I will acknowledge that there is the passive technology or passive cabling is of course necessary for retrofitting and for future proofing our parking in the longer term. However, the DM62 goes further than the building regs in providing more passive infrastructure and also more active charge points, which we see as critical for ensuring the decarbonization of travel in the district. And the viability points will be picked up on Friday.
Yeah. Okay. So you've made reference a number of times to the, and forgive me if I get the name wrong, but the electric vehicle charging supplementary planning document, which you've been consulting on. So it's my understanding that that's not in the examination library at the moment.
No.
No, but you've referred to it as being addressed in the supplement as the cost cap, in particular, being addressed in the supplementary planning document. So yes. Would it be the case that it might be helpful to me to have sight of that SPD to understand the council's rationale in that particular instance?
Yes.
So could
yes, we can provide that.
Yeah. And Mr. Dorber's got his hand up.
Thank you. Just one to flag for Friday, just looking at the council's viability assessment. I've heard what sort of Ms. Dart has said in terms of that there will still be a requirement for renewable energy generation on site. There doesn't seem to be a viability assessment of that being provided either in terms of the build cost section around paragraphs 5.20 and 5.21 or the specific section that looks into the EV charging requirements, which it sets certain standards that have been assessed in terms of numbers of fast charge points and the total allowance, but there's nothing there in terms of where the electricity to power those would come from. It's potentially quite a significant addition to the build cost because obviously cars require a lot of power. Thank you.
Thank you. Mr. Elwood, and then back to the council again.
Well, thank you, Mum. Yeah, you might recall I asked this morning about whether or not the council were going to, how the council were going to deal with these draft SPDs. We had a discussion with Mr. Tucker about that. I think in the instance of this draft SPD, you'll find it's extraordinarily detailed in terms of what the proposals are, in terms of the types of charge required and what have you. And again, I think I probably will accord with Mr. Dorber and others about the way that's been tested viability-wise. But I think you'll see there's a real raft of detail. And if it's expected that the developments that will follow through DM process later will accord with that, it's going to be quite rigorous. I think you'll really need to review that yourself at your own time.
Thank you. Would the council like to respond?
So just in terms of the viability, that will be taken care of on Viability Day. And then in terms of the SPD being detailed, the SPD was subject to pre-regulation 12 consultation in order to gather early views on the council's direction of travel in terms of EV charging. And it will take into account the discussions and outcomes of this examination.
Thank you. Okay. Anything further on the content of policy DM62? No. Okay. And then the last point was on DM64. There's a couple of changes to DM64 and additions to the supporting text. The most significant of which appears to be the council changing may seek to will require. Any particular questions on DM64? No. Okay. So as with this morning's matter and discussion of the DM30 A, B and C policies, I've got plenty to think about in relation particularly to DM62. So again, it's likely that anything on DM62 would probably be included in the post-hearings letter from me to the council in due course, but we'll be going over any modifications that we have discussed today in the mop-up session on Friday on, as Mr. Hott calls it, Viability Day. And hopefully we won't just be discussing viability all day. We will do the mop-up as well. So unless there is anything else anybody wants to raise, that concludes the matter 4 hearing on transport. Okay, so the hearing's now adjourned and we'll be reconvening here at 9:30 tomorrow morning to discuss matters 6 and 7 tomorrow. Okay, thank you everybody for your participation today and have a good evening.
Thank you, madam.
Thank you.
Thank you. Bye-bye.
Thank you, Mum.
Thank you.